appear together with me for the state.
Thank you.
May it please the court, my lord, I appear for the appellant in this matter, or the first accused in the criminal matter, together with my learned friends, Mr. Masuku, Ms. Ofa, Mr. Butelezi, and Mr. Kulu, instructed by two senior attorneys.
Yes, thank you.
As it pleases the court, my lord, I appear on behalf of the second accused.
Thank you, Ms. Jackson. Yes, Mr. Mpofu.
Thank you, my lord. My lord, if I may just start with a few housekeeping issues or signposting issues. I'm going to address there's a multiplicity of legal issues that have been raised by both parties. Points in limine and a counter application. I'm going to address those issues, the legal issues, up front. Mr. Masuku will deal with the merits of the application, namely the issue of prospects of success and other compelling grounds. Now, it's important for me to try and organize the points that I'm going to deal with, because firstly there are, as I said, a multiplicity. There are about 6 of them, but I'm going to group them into 3 just for the sake of economics. But also, my lord, to try and save time, as your lordship knows, inevitably some of the legal issues will stray into the merits. So insofar as I may deal with the merits in the context of the legal issues, Mr. Masuku will not then deal with those aspects that I've already dealt with. We have made an arrangement of which issues. So the issues that I'm likely to stray over would be the legal grounds of appeal, but the factual grounds of appeal I'll still leave to Mr. Masuku. Thank you, my lord.
Yes.
The second issue, my lord, then, coming to my section of the argument, is to just try and outline for your lordship how the legal issues are going to be approached. And as I said, there are 6 of them, and I've grouped them into 3 groups. Group 1 will be the 2 issues raised by the applicant, namely the procedure point, which I will explain later is also a section 9 point, or it has also now morphed into a section 173 point, because the defense raised by the other side relates to section 173. Then the second issue raised by the applicant is the issue of the deponent issue, Advocate Downer as a deponent. Again, I won't explain it now. I'll explain it when I get to it. Then what I call the group 2 issues will be the issues that are raised by the state, which we have to respond to. For the sake of shorthand, I call those the section 316 issues. That's because they raise primarily section 3161A, which we may call the appealability issue. And the second one is under 3165. Actually, technically, this one is raised by us, but it has been opposed on the basis that, and that is the application to adduce evidence, to adduce new evidence. I'm just grouping it here because they both come from section 316. Then, my lord, I will deal with the group 3 issues, which are part of the so-called conditional counter application. And that is the section 317 application for a special entry, and the section 319, reservation of a point of law, which is related to the section 173 point. So those are the issues that we will address up front, my lord. There may be a preliminary issue of condonation, which we understand has not been opposed. We would, if your lordship is so minded, we would deal with that now, so that we
Yeah, well, let's cut to the chase on that. I've received the application. I've taken note of it. The late filing of the heads caused because of my work schedule and having planned around that. Serious inconvenience, but I'm not wanting any further delay in the matter.
Thank you.
So you may proceed and you may refer to your heads of argument.
Thank you, my lord. We're indebted to your lordship.
But it will have certain implications, such as I'm obviously going to have to reserve because
Might have to do to the. No,
I haven't had the time to look at all the
no,
cases.
of course, my lord. No,
I've done the best that I could in the time available.
Yes, my lord. No,
Yes.
Unfortunately, Mr. Masuku's illness was unpredictable.
Yes.
Thank you, my lord. Well, then, my lord, let's then get right into it. Lord, I want, for reasons that will become clear just now, to start with what I have called the procedure point, which I will fashion as also as a section 9 point, and which the other side have fashioned as a section 173 points. Simplified, it goes like this, my lord, and it's important because it will determine which of the documents, let's call them for now, the pleadings, are in, which are not in, and why. We have raised the issue, my lord, that the procedure adopted in this matter is irregular and out of the ordinary, to say the least. And the procedure we're talking about is the directive that came from your lordship that after the filing of the application of the notice of application for leave to appeal, the state would be required, entitled, or whichever way you look at it, to file an answering affidavit, and the defense or the applicant, if they so wished, to file a replying affidavit. Now, in my experience, I've never seen anything like that. I don't know, there are maybe 12 or more lawyers here. Total, probably the experience will be more than 300 years. Maybe some of them have seen it, but speaking for myself, I've never seen it.
Can I cut to the chase on that as well, Mr. Mpofu?
Yes, my lord.
The intention was never that affidavits be filed in the application for leave to appeal. The alleged irregularity that's referred to is taken from one letter. It's not construed in the context of all the letters that were exchanged since the time when the application for leave to appeal was initially launched. And properly construed in their context, it is abundantly clear that an answering affidavit could only be filed in response to a finding affidavit. The only finding affidavit was the one in support of the application in terms of section 3165 for the further evidence, which was subjoined to the application for leave to appeal. It has been misconstrued, and in my view, in the proper context, shouldn't have given rise to this problem at all.
Well, my lord, then I will approach the matter on the basis of how we construed that directive, and how, incidentally, the state also construed it. Because when they responded, they did not confine themselves to the application for to lead further evidence.
But Mr. Mpofu, how is that relevant to whether the judgment dismissing the special plea is correct or incorrect?
It is very relevant, my lord, because procedural rights, contrary to popular belief, are as important as substantive rights. If you get the procedure wrong, or in such a way that is oppressive to a litigant, then however correct the substance might be or incorrect, then that irregularity taints the entire proceedings. That is the whole philosophy behind Section 317 and 318 and 319 of the Criminal Procedure Act. Because the so-called special entries that are referred to in those sections or points of law usually relate to irregularities outside of the merits. So it is of no use to ask why, well, let's say the merits are good or bad, and therefore let's forget about the alleged irregularity. No. Particularly in a case of this nature, my lord, and I'll explain this. That's why I was speaking about Section 9 of the Constitution. The applicant, former President Zuma, is of the strong view that at some stage this issue has to be addressed of his cases being treated differently from other cases. And as I said, and for now, my lord, let's assume that the way we have construed the directive to us and our learned friends is the correct one. I hear what your lordship has said. Then the issue really arises, because what he says is very simple, and your lordship is going to have to allay his fears. That why would a procedure that is unheard of, to put it crudely, be adopted in his case? And it's not for the first time. We all know the court can take judicial notice of the fact that he has raised this complaint repeatedly, but repeatedly. He's the only person I know, at least again, I might be wrong, there might be others, who has had to spend time in a prison cell without ever having to cross-examine anybody, without a particular process. And from his point of view, that was a unique situation that was designed just for him. He may be right or wrong in that belief, but it is a belief that causes consternation, to put it mildly. If I may digress, my lord, but it's a relevant consideration. Again, I'm speaking about my own experience. I have never seen any person, accused or not accused, in respect of whom the law seems to be so over-eager and speedy to, summarily deal with him. In the past 6 months or so alone, we have had the unique experience of bringing an application. The first one was in the Constitutional Court, which we brought in the normal course. But within 24 hours, on a Saturday, there was a directive, no, you must do this, do that. It was not an urgent application. Fine. Secondly, we've had another application relating to the parole of Mr. Zuma. Again, Part B was not urgent, but it had to be heard within the next 2 weeks. The application for leave to appeal was even heard on 21st of December. I had to cut down my holiday and rush and try and get robes in the Eastern Cape. I don't know why. But now, here again, we had the experience of the other side saying, no, this matter must be heard in November, this one. November, let's rush, and we got a directive that yes, it can be heard from the 15th of November. Unfortunately, we were not available. Again, this was just a normal application for leave to appeal. So that's the context within which President Zuma raises this point, my lord.
But you were accommodated in that respect.
No, we were. In fairness.
Yes.
No, we were, my lord.
Now, I considered it very carefully. I was concerned about a 2.5-month delay, but because of the factors that were advanced in the letter of Mr. Tusini, which is not annexed, which is one of those that I referred to, I considered that it should nevertheless only be heard today.
And give us
And it was in that context that the matter was being regulated.
Fair enough, my lord. That I accept. I'm simply saying before Mr. Tusini's letter, there was some kind of consensus that this must be done within 5 or 6 days or whatever. So it is in that context that, and even when Mr. Tusini's letter came, the Lordship told us that no, this matter cannot be delayed any further and so on. But your Lordship is quite correct. In the end, we were accommodated. Now, I'm just saying that that's what I'm back in. I'm just saying that's the context within which a litigant like Mr. Zuma is viewing these things. So when it happens now that there is a situation where he perceives that a procedure that is, as I've said, unheard of is directed at him, then he has all the right to raise that issue successfully or unsuccessfully. So that's the context. What is the connection between this and Section 9 of the Constitution? You know, when we talk about Section 9 of the Constitution, we all talk about the fashionable Section 9.3, talks about racial discrimination and gender discrimination and so on. And we forget Section 9.1 of the Constitution, which says that everyone is equal before the law and is entitled to the protection of the law, to the equal protection. Now, this is a very serious matter, my lord. At face value, it might look trivial to someone who is not in the position of Mr. Zuma. And that is because, my lord, we have to, for once, just step into his shoes and say, what would you, if your lawyers tell you that, all of them, you ask this a whole array of lawyers, and all of them say, I've never seen this procedure, and you are a lay person, what must you feel? And more so, my lord, because we are told that, you know, I cannot even count the newspaper articles or so-called expert commentators who say that every time Mr. Zuma is treated differently to other people, it is to show that we're all equal before the law. Well, that's a joke, because it can be that we show that we're equal before the law by treating a particular individual differently from all the other people. That's just wrong. So, if we are equal before the law, let's be equal before the law. Let's not have a Zuma law. Let's not have some laws that are uniquely reserved for him, because that flies in the face of Section 9.1 of the Constitution, which says we are all equal before the law. We can't be equal before the law only when bad things happen, but we are not equally entitled to all the good things. Now, my lord, the issue here is a very fundamental one, which is that the procedure was therefore, at face value, in breach of Section 9(1) of the Constitution. And apart from it being, I mean, there's such an established, applications for leave to appeal are heard day in, day out in our court. So there are established rules. It might well be, in the civil courts, we know that it's done in terms of the rules and Section 17. But even in the criminal courts, it's a common occurrence. So, my lord, the other side then says, the other side didn't come with the explanation that your lordship has just given us now, as I say, because they understood it in the same way as us. So they say no, and this is what we said in our heads. We don't know how they got into your lordship's head to know that your lordship was applying Section 173 of the Constitution, which turns out that is false now, because your lordship has just told us that the reason had nothing to do with Section 173. It was simply to deal with the Section 3165 application. So they were wrong, and maybe they can be forgiven for also misconstruing your letter. But for what it's worth, and I won't belabor this point as much as I wanted to deal with it, because now it's of academic importance, because that defense clearly doesn't accord with what your lordship has now told us. But if it ever comes again, let me put it to rest. Section 173 has got nothing to do with this approach. Section 173 of the Constitution, yes, empowers a court to regulate its own procedures. But a court cannot just regulate its own procedures in the air. There must be reasons why Section 173 has to be resorted to. And our courts have placed those reasons in many cases that your lordship is familiar with, as versus Atchison, the cases that the prosecution relies on in this regard include Phillips case, SABC case, and S versus Western areas, to mention a few. And we all know they claim that it is nevertheless in the interests of justice, or to make matters worse, they claim that it was in the interest of justice and presumably in Mr. Zuma's own interest that such a unique procedure be adopted. Well, to paraphrase, and as I say, I'm not going to go deep into those issues. Nothing could be further from the truth. It has been said repeatedly that the courts must resort to Section 173 in order to assert their impartiality. And it has also been said that resort must be done sparingly and only in the clearest of cases. And when, according to the Phillips case, at paragraph 48, to meet an extraordinary procedural situation pending enactment of relevant legislation and promulgation of rules of procedure. It may be that the High Court could legitimately claim inherent power of holding the scales of justice where no specific law directly provides for a given situation. All that does not apply here. I just want to jump some of this. And yes, okay, to save time, I won't go through the grounds given in Pennington. As far as Pennington, I'll just give your lordship the citation. It's 1997 4 SA 1076 CC. And interestingly, one of those grounds deals with applications for leave to appeal, but I just want to move on. In the Western Areas case, my lord, it was stated there, and I want to, I'm addressing this to kill two birds with one stone, also to deal with this issue of speed, what I call undue speed, of trying to deal with these matters. There it was said, my lord, that it is surely not in the interest of justice to submit an accused person to the strain, expense, and restrictions of a criminal trial if it can be avoided in appropriate circumstances by allowing an appeal to be pursued out of the ordinary sequence, and so obviating the trial or substantially shorten it. And I'll come to that question when...
What paragraph are you referring to there?
It's 28, madam.
28, thank you.
I'll deal with that. I won't quote it again, but I'll refer to that paragraph also in the context of the objection by the state that this application should be brought only at the end of the trial. Or something like that. Which, by the way, there's another overlap with your lordship's findings. If your lordship allows me just to also flag that issue, I'll come back to it. Mr. Masuko might also deal with it. But let me just say this now so that it's out of the way. The governing philosophy of this judgment that we are here about is that this matter, this plea, this complaint about Advocate Downer should be raised at the end of the trial. Or should not be raised at this stage. Or words to that effect. I'll go to the judgment itself. Well, on that ground alone, on that basis alone, the application for leave to appeal, at least on the merits, should be granted. Because the cases, such as the one I've just cited, are replete with references of the fact that it is not in the interest of justice to submit an accused person to the strain, expense, and restrictions of a criminal trial if that can be avoided in appropriate circumstances by allowing an appeal to be pursued out of the ordinary sequence so as to obviate the trial or to substantially shorten it. Now, all that is cast aside when it comes to former President Zuma. No, he must be put to that strain and the expense and the personal restrictions. An old person must sit here for 6 months going through a trial which might be of academic use because he must only complain about Advocate Downer 6 months or 12 months or 18 months down the line, however long the trial is going to take. How can that be justice? How can that be even approximately called in the interest of justice? Justice to who? Now, coming back to the issue of the deviations. Our learned friends say that we must show that there was prejudice. Well, there's no such requirement in law with respect. If a constitutional violation has been made against you, you don't have to show prejudice. That is the prejudice. The fact that your constitutional rights have been violated. You can't insult a person for argument's sake. And then when they take it to court, you say, well, or call them a kafir or whatever appellations are used to insult people. And then say, no, what is the prejudice? That's the prejudice. The mere fact that you have violated their Section 9 rights is prejudice. The prejudice which they refer to is in another context, which I will deal later, but not in this context. So there is no law anywhere. In fact, let me put it this way. Section 173 must be used to assert the impartiality of the courts, not to practice it, not to assert the exact opposite and the unequal treatment of people, because that would just be doing violence to the intentions of the drafters of the Constitution. So, my Lord, we, on the common understanding of the parties as to what your directives were saying, then it is a matter of serious grievance on the part of the applicant, because there is no reason. As we know, rights can be attenuated, even his Section 9(1) rights, but there must be a justification, and that justification cannot be the fact that his name is President Jacob Zuma. It must be a rational justification, and none has been offered. I may come back to this, but for the sake of time, I want to move on oh no, let me also say this, because it might help us when we get to the special entries or the counter application. We have entered a special entry and raised this matter also as a question of law. And I don't have to repeat how we frame it and view it as a question of law. It's obviously a question of law whether somebody's rights under the Equality Clause have been observed or not, or whether he has been singled out for special treatment. But that question is a question we seek to place before a higher court, specifically the SCA. And we do that in terms of Section 317, alternatively 319 of the Criminal Procedure Act. But let me explain something, my Lord, just for, it's a procedural point. The reason why we call that section conditional counter application is because, of course, it is dependent on the finding on the merits. We acknowledge upfront, and there's authority for that, that should leave to appeal be granted, and your Lordship knows that your Lordship has acted in the SCA. The SCA would be at large, for lack of a better word, to deal with all the issues that may be raised at that stage, including so-called special entries and what have you. All legal points. It's no longer like in the olden days where you are restricted to your notice of appeal. You may raise now any issue that is valid. So it's conditional in that sense. If your Lordship, after Mr. Masuku's address, finds that either there are reasonable prospects of success in the merits, or there are compelling reasons why the application for leave to appeal should be heard, then all these points will fall into that category. But if your Lordship finds that those standards have not been met, then your Lordship, with respect, has no option but to still grant the application for leave to appeal on the basis of the special entry and the reservation of the question of law. This is not a matter that is within the discretion of your Lordship. Once you've entered a special entry, then your Lordship has to refer that to the what was used to be called the AD and now called the SCA.
We take it, Mr. Mpofu, that although the notice referred to full court or SCA, you're talking about the SCA here.
Yeah, my Lord, yes, I'm sorry, I should have made that clear, my Lord. The standard notice that the...
No, that's fine.
Yes,
you don't have to explain it.
No,
You confirm
and I'm
it's
sure
SCA.
Mr. Breitenbach will also approach the matter on that basis. Yeah, well, we're really talking about the SCA for various reasons, my Lord, including the fact that there's SCA authority which is contested here. So, with the greatest respect, a full court appeal would just be a waste of time or cause further delays. In our respectful submission, the matter should go straight to the SCA. So,
Mr. Mpofu, why were there two replying affidavits filed and this issue not dealt with simply in the affidavit of Mr. Tusini?
I'm sorry, my Lord, I didn't get that.
Why were there two replying affidavits filed and this issue of the alleged irregularity not simply dealt with in the affidavit of Mr. Tusini?
Okay. No, the reason for that was to underscore the point that we were making, that we remember that in the replying affidavit that was signed by Mr. Zuma, he says that we concede the fact that as far as the application for to adduce new evidence is concerned, the affidavits are allowed, but we contest the other. So it was really merely to underscore that point, and that is why we did not want to be somebody to come later and say, well, you've now replied, therefore you have acquiesced in this irregularity, because we have not. So we accept that the replying affidavit of Mr. Tusini in the other application is quite competent. We don't take that point. And by the way, our learned friends are completely wrong, because they say by adopting that procedure, we were thereby conceding that you can adopt a procedure which deals with affidavits even if it's not prescribed by the law. Well, that can only mean that they have never read section 3165B of the Criminal Procedure Act. So on my version it's at 31-6. Because that section makes it clear that affidavits are not only allowed but prescribed. It says an application for further evidence must be supported by an affidavit stating that, and so on and so on. So that point is just a non-point. And there's no equivalent section, at least in criminal proceedings, we know that, and they also make the issue about the petitions to the SCA. That's also a non-point, because in the SCA, when you do a petition, by definition, you do an affidavit, a filing affidavit. You don't just start with an answering affidavit. But anyway, be that as it may, at least Mr. Zuma, even though he's not a lawyer, he has done petitions to the SCA. He knows that those are done on affidavit, and that situation is not comparable to what we're busy with here today. Now, I'm raising this point of the 317 and 319 in relation to what we are discussing now. A, to save time so that when I get to the so-called group three issues, I don't deal with it, but also to underscore the fact that it underpins the reservation of question of law which we have raised, as well as the special entry. And as I say, even if unless if your lordship use the same, is of the view that the point is not raised bona fide, or is frivolous, then your lordship has no option but to enter the special entry. And I've already explained why it is not by any stretch of the imagination frivolous or trivial. It is one of the most fundamental issues. Section 9, the equality clause, is very, very important, particularly to a person such as Mr. Zuma, who has been a victim of its violation at the expense of his own personal liberty. And it must stop somewhere. And this is the somewhere. Or well, maybe not this is the somewhere. The somewhere will be the SCA when that issue is raised there. Now, the lordship just bears with me. Go to the SAB's case. Yeah. At paragraph 49 of the SABC case that is relied on by our learned friends, the connection between section 173 and the fair trial rights is made in the middle of that paragraph 49. It says, moreover, the test adopted by the Supreme Court of Appeal inevitably and permanently privileges the right to a fair trial over the right to a public trial, the right to freedom of expression, and so on. In doing so, counsel argued it creates a hierarchy of rights inappropriate for a constitution such as ours.
So what paragraph is that, Mr. Pofu?
49.
49, thank you.
Yes, 49. There is another more appropriate quotation. I'm sorry, my lord. I'm struggling because I'm using my learned junior spec. Let me use mine because it's underlined at the right places. Yes, paragraph 17, my lord, of the SABC case says that the reach, or rather it says, while the clarification and protection of the powers contained in Section 173 are matters of substantial importance, the Supreme Court of Appeal does not affect the substance of Section 173 in a way which renders it desirable for consideration by this court. That's what was argued, that this was not a matter of substantial importance, the ambit of Section 173. And the court, this was the Constitutional Court, and it was SABC versus National Director of Public Prosecution and others, 2007 1 SA 523 CC. The court said, we disagree. The reach of a court's power to regulate its own process is an issue of great constitutional moment, and the current dispute raises the issue directly. In addition, the contention ignores the other constitutional issues of importance in the case, and in particular, the ambit of the constitutional protection of the freedom of the press. In this case, you might replace that with the freedom of equality before the law. And then, this is Langer, Chief Justice Langer, then went on to say at paragraph 35, Section 173 provides that, then he cites the section, this is an important provision which recognizes both the power to protect and regulate their own process, of the courts to protect and regulate their own process, as well as the power to develop the common law. It is the former that is of relevance in this case. It must be understood in the context of Section 165, which provides that the judicial authority is vested in the courts, and that they are independent and must apply the law impartially and without fear, favor, and more importantly, or prejudice. And the next paragraph says, a primary purpose for the exercise of that power must be to ensure that proceedings before the courts are fair. Goes without saying that anything that is in breach of Section 9 cannot be fair. That would just be an oxymoron. Not something that is a source of inequality cannot at the same time be fair. It is therefore fitting that the only qualification in the exercise of that power is that courts in exercising this power must take into account the interests of justice. I've already addressed that. And it says, when the courts exercise the power to regulate their own process, it is inevitable that that power will affect rights entrenched in Chapter 2 of the Constitution. The court must regulate the way proceedings are conducted, and this will inevitably affect both the right to a fair trial and the right to have disputes resolved by the courts. Courts are bound by the provisions of the Bill of Rights and therefore bear a duty to respect those rights. In exercising the power, therefore, they must take care to ensure that those rights are not unjustifiably attenuated. That's the nub of the issue. The other side thinks that we are questioning the power of the courts to exercise Section 173. No, we're not doing anything of that sort. We're exercising whether it has been, in this case, exercised justifiably or unjustifiably, which is what the Constitutional Court said is the standard. Sorry, my lord. I promise, my lord, that I want to. Then, of course, the Constitutional Court said in the case of Phillips and others versus National Director of Public Prosecutions, in both, paragraph 48, my lord, in both cases, the points are made that ordinarily the power of in Section 713 to protect and regulate relates to the process of the court and arises when there is a legislative lacuna in the process. The power must be exercised sparingly, having taken into account the interests of justice in a manner consistent with the Constitution. So I doubt that the inherent jurisdiction of the court under Section 173 is such that, I'm at 52 now, my lord, is such that it empowers a judge of the High Court to make orders which negate the unambiguous expression of the legislative will. Moreover, the power that the court has to use in its inherent power is a special and extraordinary power which should be exercised sparingly and only in clear cases. This is not such a case. That's just a cross-section of the authorities of the Constitutional. So it's a serious matter. It's as far as special interests are concerned, or even as we raise it here, which has to be adjudicated. Starting, of course, now, given what has been said in court, it will have to start with the proper interpretation of the letter, because clearly and we accept that your Lordship's word on what was meant to be conveyed, but we in our respectful submission, the common understanding of the parties was different to that which we only hear for the first time now.
Also, I think I understand the point.
Yes,
Under this heading. I don't want to rush you along,
no.
but we sat down for today.
Yes.
I didn't ask you at the outset what sort of time intervals you were looking
Yes,
at,
my lord.
but I think you've concluded now what you referred to as your first point,
Yes.
the procedural
I've
issue.
actually concluded three, my lord.
Yes.
Maybe your Lordship did not. Let me explain.
Now, you've touched on part of 3 as
Yes, of three issues, yeah.
Yes.
I'm not, that's the whole point I was making. I'm not going to then go back to section 217 and 219, because the point I'm simply making is that your Lordship, if your Lordship is conditional in the sense that if your Lordship finds against us on the merits, then those will kick in. But if your Lordship finds for us, then your Lordship doesn't even have to address those. So we've done 3 points actually.
Very well.
We're doing very well. So then, let me then quickly dispose of the fourth point, which is the issue of Mr. Downer's
The deponent issue.
the deponent issue, my lord. Yes.
Okay.
Well, that issue must be married together with one of the issues that Mr. Masuku might raise on the merits, and it is this, my lord. Let me paraphrase it. The applicant's objection is that of all the people in this world, the NPA has chosen that the person to depose to its affidavit in this matter, which involves the title of Mr. Downer's title to prosecute, is Mr. Downer. That is just patently wrong. Your Lordship knows, just by way of example, that one of the issues in Porritt, in the famous Porritt case, was and you'll find that even in the heading, it says the court upheld the plea holding that there was no reasonable explanation before the court why, as a prosecutor employed within the NPA, Ferreira, whoever he is, will be involved in drafting an affidavit in respect of a civil matter. So this cuts 2 ways. Firstly, the Lordship knows that one of the issues raised on the merits of the section 106(1)H matter was the filing of an affidavit by Advocate Downer in support of the DA on our version, on their version just to assist the court. I'm not entering that debate now, but I'm simply saying that that is but one of the issues that we raise. Now, we come here, and as we point out, my lord, in Mr. Downer's favor, a point in Mr. Downer's favor, when this issue was raised of his title to prosecute, he, I won't go as far as to say he recused himself, but it was clear to him that somebody else had to argue the point, and that's just not even in terms of the law, just out of ethical duty as well. But that was in a situation where we were simply complaining about breaches of the prosecutorial code and all sorts of things like that. Now we are in another terrain altogether. On the 21st of October last year, former President Zuma laid criminal charges against Mr. Downer. And that is a matter that is before you, my Lord, in the application to adduce new evidence. I don't want to deal with it now. So, in which world is it acceptable that a person who's being investigated is clearly not an accused, but at best for him is a suspect? That person, as I say, of all the human beings in South Africa, is the only person that the state thinks is competent to file an affidavit, assuming for a minute that affidavit is even lawful. It can be. On the facts of Porridge, of course, that was found, rather the Kota Core actually had found that the Mr. Ferreira's involvement in a civil case, such as the D8 case, which obviously was a separate one, was enough to strip him of his title to prosecute, and the SCA, for reasons that are unrelated to that ethical issue or professional issue, found otherwise. But the point doesn't. The case in the Porridge case actually overemphasizes the need for prosecutors to be beyond reproach. So that's the gist of that point, my Lord. And we say therefore that application, that affidavit should be read as pro non scriptum on that basis alone, irrespective of the other point. So that's the fourth point then, man.
Yeah.
And then, of course, my Lord, that has a bearing, by the way, on the application for evidence, for further evidence. Because even if we accept your Lordship's explanation, as we do, at least from a professional point of view, that the only affidavit which was allowed, which we have already said in our own affidavit, was the affidavit in relation to the leading of further evidence. Then even that affidavit was answered by Mr. Downer irregularly in our respectful submission. And therefore it should be taken as pro non scriptum, even from that point of view, even in your Lordship's explanation, it would be at least narrowly then stripped of its existence in respect of Mr. Tusini's part of the exchange. That then takes us to what I've called the section 316 issues. And maybe because of, if your Lordship allows me to start with 3165, just because we are already talking about the application to adduce evidence. Well, that application is, quite frankly, there's no logical explanation why it is opposed. But we will hear, I'm sure, very soon why it is opposed. Because the criteria that are needed, that application, as I've already pointed out, is about the introduction of the new evidence of the criminal charges that have been laid, as well as the supporting statement of Mr. Zuma in that application, or rather, at the police station. Which your Lordship will find that I'm sorry, my Lord, it's Mr. Tusini's affidavit, it's 27, page 27, onwards. And attached to that, your Lordship will see something called at page 32, sworn statement in support of criminal complaint, which is an affidavit signed by the applicant, and he explains the charges in terms of section 41.6 and 41.7 that you'll find at page 34, my Lord, of our bundle. And then it sets out count 1, count 2, and so on. And it's signed at page 39. And attached is a special power of attorney and so on. But let me paraphrase what's going on. What Mr. Zuma is simply saying is that this evidence, which elevates the earlier complaint, remember the earlier complaint was related to Mr. Soul and those kinds of earlier complaints. And it is now amplified by the latest, let's call it News 24 complaint. But now it is further amplified by the criminal charges laid in respect of that News 24 complaint. And all Mr. Zuma is really saying is it should be this. Honestly, I don't understand why anyone would resist this. All he's saying is that that charge was laid well after we argued this matter on the 22nd of September, the second day. And that charge was laid a month later, 21st of October. And therefore that fact, which might have a bearing on the title to prosecute, must just be taken into account and accepted or rejected or whatever. But it must be taken into account. And so it's relevant, clearly it's relevant, because it's relevant to the two previous issues. There's an explanation as to why it was not before the court by the time we finished our argument, because those charges, in fact, those charges had not been laid. In fact, Your Lordship will remember, unfortunately we don't have a typed record here, but I'm sure, I don't know if Mr. Breitenbach was here, but at least Mr. Trenkov and the rest of the team will remember that I stood here on the 22nd in the morning and I said, this is the situation, these are the sections of the act that have been, of the NPA Act that have been breached, and Mr. Zuma is minded to lay criminal charges. Your Lordship said to me, Mr. Mpofu, we cannot discuss that because those charges have not yet been laid. And Your Lordship was correct. And I moved on to something else. So I can't be told now again, now the charges have been laid, that matter must be considered when the matter goes further. So quite frankly, there's no reason why Your Lordship should not accept that new evidence. And Your Lordship knows that unlike in civil cases, in criminal proceedings, or rather in criminal appeals, it's quite a strange process, by the way. The application to adduce new evidence is done here in the trial court. And the SCA, actually you're not allowed to bring it for the first time in the SCA, unlike in civil proceedings. So all we would like is to say that application ought to be granted. Now if I may then come to the last issue of the 6 issues, and that is seemingly attractive notion raised by our learned friends to the effect that we should not be appealing at this stage because Section 316(5), or rather 1, of the Criminal Procedure Act says that you can only appeal once there's a conviction or an acquittal. I will demonstrate that that defense is just baseless, and it is not in accordance with our law. It is not in accordance with the rules of interpretation, and it is not in accordance with binding constitutional court authority. It is indeed so that Section 3161A talks about offense, allow that court for leave to appeal against such conviction or against any resultant sentence or order, and in many other places. Nobody is going to quibble with that. But my Lord, this matter must be looked once again. You know, we live in a constitutional state now. So the interpretation of that section firstly has to take into account the broader standard of interests of justice, issues of appealability we shall deal with now, and whether such a narrow and parsimonious interpretation can be entertained in a constitutional framework. Because what this would mean really is that, once again, you must wait. You can have the biggest grievance in the world, life-threatening, but you must go through the tedious and expensive route of a trial, and then one day say, oh well, I don't even know how you do that. Even if you are acquitted, let's say you get acquitted, then it means your complaint just fizzles away. But let's say you are convicted. And then at that point only, you must ask for leave to appeal against that finding that happened 2 or 3 years ago. And that's just patently ludicrous. Now, the way the courts have approached this, my Lord, is that there are two ways. One is from the point of view of appealability, which we know, which also applies in the civil law, the Zweni test and all that. But it has also approached it pragmatically in relation to criminal matters, in what I will refer to as the Basson test. Now, my learned friends, unfortunately, have attached the wrong Basson cases, and I don't blame them. There's so many of them. So, but the Basson matter that we are referring to is the 2007 matter. Yes. The citation is 2007-1 SACR 566CC. It's a decision of the Constitutional Court. And that decision, my Lord, put paid to the theory advanced by the state. And
which paragraph are you relying on, Mr.
Of 152, my Lord.
152.
Paragraph 152, yes.
Thank you.
That shall come to me. Now, at paragraph 152 of Person, it is stated that and I'll link this to the 216. But in our view, section 219 should not be considered to prevent an appeal against an order dismissing or upholding an exception. The section should be construed so as to allow the state or the accused to appeal against an order upholding or dismissing an exception. Such a construction of section 219 brings with it constitutional bounds by recognizing the rights of the state to institute criminal proceeding and if need be to appeal an adverse finding on a question of law. It is this construction which must be adopted. It follows therefore that section 319 did not prevent the SCA from considering an appeal against the order of the High Court quashing the charges relating to conspiracy. The SCA therefore erred and concluded that the Adams rule, that's the old rule that they rely on, constituted a bar to the reservation of questions of law relating to the quashing of the charges. Now, the relationship between 316 and 319 in this context is quite simple. But for shorthand, I'll just refer your Lordship to, okay, this one I'm sure it's quite correct, it's the latest, 31-12 or in due 12. In the middle of that page, it says, after stating, my Lord, that it was previously believed as in Adams and so on, it says, an order dismissing or upholding an exception is appealable before the conclusion of a trial, as versus Person, with the thing at paragraph 152. A plea objecting to a court's jurisdiction in terms of 106(1)(f) is indeed such an exception. An appeal against an order dismissing a plea of no jurisdiction will be entertained before the conclusion of the trial, where it is clear that the court dismissing the plea had no jurisdiction, and in addition, where it is clearly in the interest of justice to permit an appeal against the ruling without an appellant first having to be exposed to the prejudice of an irregular trial. So you can then transport what I said earlier about the expense and restrictions of a criminal trial from West versus Western areas. Again, I said it will be relevant again, that is relevant.
Mr. Pofu, what is the legislative basis for that?
Yes.
Was it based on the word decision, and any decision of a court
Yeah.
may be taken on appeal as used in section 21, subsection 1 of the Supreme Court Act? Because I don't have a difficulty with that.
Yes, ma'am.
Where the difficulty comes in is from August 2013, when that section 21(1) and the reference to decision, which I take it as the statutory basis upon which the Bassoon case was decided. I haven't looked at it, but certainly it featured in the Western Areas judgment. And that was changed because of the provisions of the Superior Courts Act.
Yes.
And I think that's the thrust of the state's
Of the
argument.
objection. No, fair enough, my Lord.
It's really, I don't quite know what weight one can still attach to the pre-2013 jurisprudence on this issue.
Yes, my Lord. My Lord, I can assure your Lordship that that case, remember, that's exactly why I said, my Lord, there's a route, the Zweni route, which deals with all those issues. Is it a decision? Is it final in effect, and so on and so on? Mm-hmm. That's the one leg of approaching the matter. And I'll address it just now. I'm now addressing the leg of, firstly, interest of justice, but also the interpretation, whether the word conviction should be interpreted narrowly to prohibit an appeal at this stage. Unfortunately, my lord, if your lordship also has an updated book of the toy, your lordship will see that this case is cited in the 2021 in the current, so it's clearly not affected by whatever legislative changes might have been to Section 21, but also, more importantly, this part that I just read out comes out of the commentary to Section 316, and the heading there is matters which are appealable. So it's exactly the point that has been raised. The short point, my lord, is this.
Sorry, could I interrupt you? Could I ask you, your junior, to make copies of those, because our loose leaf volumes have fallen
I know, my lord.
way behind,
I know.
and they're not going to be apparently replaced.
Updated soon. Thank you, my lord. No, yes,
So if it's 2021,
yeah.
the law report stopped from 2019, so I don't think I would have those.
No, you won't.
You can, even if it's dropped off just at the end of the day with my
We will, my
registrar.
lord. We'll actually, it's a two-page section, the section on appealability.
As long as it
We'll
just,
click,
thank you.
As God pleases, my lord. Now, I was saying, my lord, that the Basson case, really the shorthand, if we want to cut to the chase, is that it did away with the Adams approach and dealt with the matter in relation to Section 1061F of the Criminal Procedure Act. And my lord, it's what we lawyers call a fortiori. If I can borrow, can I borrow?
Yeah.
Thank you. So my lord, I didn't bring the big one, but fortunately Mr. Breitenbach brought it. Your lordship knows the pleas A to AI under Section 101, rather 106. And one of them is that the court has no jurisdiction to try the offense. Incidentally, that's the one that has been singled out as is not capable to lead to an acquittal. So it's a lesser being, that section. It's literally, it's like an exception even in civil proceedings. But the Constitutional Court has found that even for Section 161F, a matter is appealable because it would be in the interest of justice, again, to avoid a lengthy trial which has no legal basis. So how much more for Section 1061H, read with Section 1064, which are the sections that may lead to an acquittal. So a fortiori, as lawyers would say, if you can appeal against a 1061F finding, which is clearly intermediate, to avoid the confusion between interlocutory or otherwise, then it's clear that what the Constitutional Court was saying, based on the issues that I've raised, was that it would be absurd to the extreme to subject a person to a trial. And as the court said in the quotation I said earlier, it is surely not in the interest of justice to submit an accused person to all that. Surely. So surely the objection based on the narrow reading of 1064 negates logic and the interest of justice, if we understand what justice really means. The other point related to that is the fact that is a point that we have made, my lord, but I don't want to, again, to develop it. It's a construction point. So we say, if we all accept that one of the outcomes of the process that happened here could have been an acquittal, one of the logical outcomes. And then at that point, the matter would have been appealable, even by the state for that matter. Then, as a matter of logic, the non-acquittal or the failure to acquit, which is really what transpired, must also be susceptible to a challenge by the victim thereof. Surely, again, I'm sure that's what the Constitutional Court would say. But the bottom line is that it is surely not in the interest of justice to submit him to a lengthy trial, or to submit anybody, but for that matter, even the court, to a lengthy trial which may come to zero. Just rounding off, my lord, this, I can feel it in my body that there's a particular passage that I have not read out.
This is the last point that you're dealing with in your address, Mr. Mpofu. Yes, when you're done, then we'll take the shorter
We'll
journey.
take a break, that's right.
I assume, rightly or wrongly, that you might be winding down on your point.
Yeah, no, you assume rightly, my lord. That's why I'm just looking for, just to see that I don't have to rise up again. Yes, no, let me come back to that point which I made earlier, where the connection between what I've said is the fundamental bedrock of this judgment, and because it also deals incidentally with the res judicata and issue estoppel point, so it will relieve Mr. Masuku of having to deal with that. My Lord, the fundamental error, with the greatest respect, that your Lordship made in relation particularly to the Zuma versus DA matter was this: the accused person, former President Zuma, an applicant in this matter, is left in a no man's land of the judiciary. The Supreme Court of Appeal, or rather even this court, when there was an application for a stay, says we cannot deal with this matter. It must be dealt with. All these complaints you are raising about Mr. Downer and all sorts of other people must be dealt with by the trial court. The trial court is you, my lord. We all know, at least your lordship says in the first part of your judgment, that the trial commenced in May 2021, correctly so. Because on the day that we submitted our section 106 and 1064 and 115 statements, the trial started in earnest. And the plea process is part of the trial. There's so much authority on that. I don't even need to convince your lordship about that. So if we all accept, therefore, that we are now in the trial, then it means we're at that place that these previous courts were saying the matter of Mr. Downer must be dealt with. But Your Lordship, with the greatest respect, makes two fundamental errors. One says that this matter must also be postponed to some other stage called the end of the trial. And I've already addressed why that is manifestly unjust.
I don't think I said just the end of the trial. More generally the end of the trial, unless in the discretion of a presiding judge he decides during the trial. But anyhow, it's on the record.
I'll take Your Lordship to your judgment, but my team will look for the passage. There's more than 5 or 6 places where Your Lordship says that the matter should be entertained at the end of the trial. But for now, let's assume I'm correct. The second problem with that, my lord, is that Your Lordship then also upheld the res judicata and issue estoppel objections with respect erroneously for 2 reasons. One, because those points had been abandoned, for lack of a better word, by the NPA, and that's why we didn't even address them seriously, because they had correctly considered, particularly in the question of issue estoppel, that it might not even apply in South African law. But let's assume we're wrong, because of course, as I would, they don't want to look a gift horse in the mouth. So they've now resuscitated those points which they had abandoned. That's fine. But on the merits of that, my lord, that upholding those points loses a very significant matter and is severely prejudicial to the interests of Mr. Zuma. Why? Because it cannot be that he is told by those courts that this matter must be dealt with here. And then when he comes here, he's told that those matters are res judicata. That means there's no court in this world where he must be able to raise this issue. He must be caught in this merry-go-round of judicial passing of the buck. So we can't, my lord, have a situation where Mr. Zuma is not able to assert this, rightly or wrongly, win or lose, we don't care. But there must be a forum in this country where he is able to assert his complaint. May I pause, my lord? I know that there are many references, but for now I'll give you this one, my lord. The Lordship said at paragraph 135, against the letter F, which is on printed page 57 of your judgment.
Yeah, the passage I think I mentioned earlier, I think was made in the context of referring to Delport's case. But we can read that, Mr. Mpofu.
Yes, I know. Yes, there is also that part here, where it's dealt with in relation to
because there it arose during.
Yes. The Lordship said that imperative remains even on the evidence adduced in the affidavit to date. It is concluded that it has not been established that Mr. Zuma has or will suffer child-related prejudice and so on. This judgment cannot stand in the way of possible fresh evidence emerging later. Well, that's also important, by the way, in relation to the new evidence issue. The Lordship again was correct, but this is the point. The inquiry is one most best answered by the trial court at the end of the trial, when the materiality of all the evidence adduced can be assessed properly. That's what your Lordship said. Yeah. And that's what we say is fundamentally unjust and fundamentally incorrect. Yes. Paragraph 77 as well, my lord. Actually, these paragraphs, ironically, are quoted in the heads of our learned friends. The Lordship said, but that is something, Mr. Zuma's fair trial arise during the trial when they can be revisited to ensure at the end of the trial, Mr. Zuma will have received a constitutional fair trial. But there's something to consider during the trial only when the materiality of any such allegations in respect of issues and evidence revealed to be relevant are established. Any infringement of fair trial rights, which is the true basis of Mr. Zuma's complaint, is best determined when the evidence in the criminal trial has been heard, digested, and in the light of conflicting evidence, and the credibility to be attached to the evidence has been properly assessed. And this is what also was said in the spy tapes case. Your Lordship said, the possible infringement of fair trial rights does not arise for consideration under the special plea. That was the bottom line. That is what I call the heart of this judgment. The heart of this judgment. And that is fundamentally incorrect, my lord. Because why would anybody have to wait till the end of a trial if their Section 35 rights guaranteed by the Constitution are being threatened at any stage? Surely, the correct position in law is that that is exactly one of the considerations in the Basson line of cases. Yes, the point, I can, just to save time a lot, the Lordship will see that in the heads of the state, it's also, well, again for understandable reasons, the heart of their defense, which is say, no, let's do this at the end. Forget about whatever prejudice may have been suffered now. We'll see it in 2025 or whatever. Now, that gist and what I've called the heart of the judgment, my lord, is a manifestation of the greatest form of injustice. And in cases such as S versus Twala, which the other side have relied on, it has been made very clear, my lord, that one of the fundamental rights enshrined in our Bill of Rights is Section 35.3.0. We know that Section 39.2 says we must construe all these things against the Bill of Rights. Whenever you are interpreting any legislation, you must do it in conformity with the Bill of Rights, for obvious reasons. So what does the Bill of Rights say? It says every accused person has the right to a fair trial, which includes the right, 35.3.0, of appeal to or review by a higher court. Now, that right, with the greatest respect, cannot be sacrificed at the altar of just speeding for the sake of speeding. That right, if it's going to cost us time, so be it. So be it. But that right cannot be abrogated. It's a fundamental right. The drafters of the Constitution knew what they were doing. They didn't say an accused person has a right to a fair trial, which includes the right to appeal at the end of some lengthy trial, which might be expensive and to their detriment. So even looking at it from that point of view, from a purely interpretational point, my lord, it cannot be that these matters must be relayed to the end of the trial. I'm saying now on the merits, but I'm also saying in the context of what I'm saying in relation to the conviction point, it also relates to the right of appeal per se. And secondly, my lord, the lordship quite correctly, I have to give credit where it's due, has articulated the interconnectedness between the 1061H plea and the Section 35 in general. In other words, that these are two sides of the same coin. Surely then, the enjoyment by Mr. Zuma of his Section 35 rights cannot be postponed to some future unknown date. They must be exercised now.
Are those your submissions on this point, Mr. Wolford?
I'm sorry, Miller?
Are those your submissions on this point?
On this point, Miller, I'm just checking.
Mr. Wolford, I'm worried about the time allocation.
Yes.
Without wanting to rush you, because this matter is set down for one day.
Yes. Well, my lord,
You've had an hour and almost 45 minutes now, and Mr. Masuku must still speak.
no, Mr. I've
And I
taken
don't want
Mr.
to-
Masuku's some of his time, so I'm using it.
Yeah, and I want to allow the same amount of time, obviously, for the state.
No, fair enough. Okay, well, I don't know what your lordship wants to do. If your lordship is saying, let's say, for argument's sake, if you are saying we have 2 hours, then we can make sure that in our internal allocation we do it that way, and so on. I'm quite happy to work with the court.
All right. Well, I think you
But
can
not at the expense
you
of-
can discuss that with Mr. Masuku and with Mr. Breitenbach, and then when we
Yes.
return,
Yeah. Well,
because I
can-
understood that this was now the part that you deal with.
Yes, yes.
So
my
you've
lord.
concluded that.
Yes.
So let's take the short adjournment, and then you can. You've dealt with a number of issues that I understood Mr. Masuku was going to deal with.
Yes.
So maybe it can be curtailed, and he can be
He'll be very short. my
kept
lord.
to another 20 minutes or so.
Yes.
And then Mr. Breitenbach can start, and we can.
Can use the time.
Because I'm
Yes,
sure
my
you
lord.
also want to leave. You want to go somewhere else.
Thank you, my lord. I have to be somewhere else myself
I'm aware of it.
tomorrow.
Yeah.
Thank you, my lord.
We're all waiting with bated breath.
Yes, thank you, my lord. Yes, my lord, I agree with your lordship. What I'm proposing then, my lord, is that in any event, when I finished, I was going to ask for a break so that we can cut down on
All
Mr.
right.
Masuku's address. So maybe let's take that break now. If
Yes.
I address you at all, it will be a minute just to wrap up.
Yeah,
and
it'll
then
be, it's now 22, so you've had an hour and 40 minutes. We'll take a 15-minute adjournment.
15.
We'll start at 5 to 12, and then hopefully Mr. Masuku can
Mr. Yeah, Mr.
wind up
Masuku
on his
will-
section in
No, my lord,
15 or 20 minutes,
Yeah.
so that we can move on to Mr. Breitenbach then.
My lord, I'll use my privilege as the leader of the team to suppress Mr. Masuku.
Very well.
Some of Mr. Masuku's.
We'll resume at 5 to 12. Court will rise.
versus King, 2010-2 SACR 146 SCA is one of the cases cited by my learned friends. And the Lordship could go specifically paragraph 41 thereof, and the judgment of Nugent J.A. at paragraph 52.
At, sorry, 4?
52.
52.
41 and 52. Yeah.
Thank you.
And the one at 52 makes the point about appealability in matters such as this, and it says, if the order was erroneously granted, I have no doubt that this is the time for the error to be corrected, failing which it might just as well never be corrected at all. Then, my Lord, the closer to home, the Constitutional Court in the case of Tint versus National Public Prosecutors and others, and Zuma versus National Director of Public Prosecution, 2009 1 SACR CC. The Lordship will find the relevant portions at paragraph 62 to 65, where it talks about leave to appeal and the interests of justice.
Yes, okay, thank you.
And that there they just say, generally disallowing such litigation would ensure that the trial court decides the pertinent issues which is based to do, and would ensure that trial starts sooner rather than later. So we accept that there's a need to over that. But says there can be no absolute rule in this regard, however. The court's doors should never be completely closed to litigants. If, for instance, a warrant is clearly unlawful, and that was on the facts of that case. So just pointing your Lordship to those references. Then the second point, my Lord, which I have to get off my chest, and is what I will call one of our grounds of appeal is that this court, with the greatest respect, completely misconstrued or rather misapplied, maybe, Nduli and Porrit. Nduli, on the basis that we argued then that it was a pre-constitutional dispensation. It was basically interpretation which had nothing to do with Section 39(2), and should therefore not be relied on, or relied on with much caution, because that interpretation was clearly narrow because of its time. And then Porrit, more importantly, my Lord, this is really, it's almost painful to have to discuss this. Porrit does not say what the judgment says it says. I made this clear, at least I got points from Mr. Chenkov then, for my Afrikaans, that all Porrit does say is that it is not necessary, and I said, it's onnodig, on nie noodzaklik nie, that the removal of a prosecutor be done under 1061H. When you say something is not necessary, it doesn't mean it's prohibited. So this distinction between a removal and a lack of title is really not helpful. The only thing that Porrit said was that it's not automatic that you'll get an acquittal. There should be a further inquiry, 1064. You'll remember it was the so-called continuum debate that I had posited, my Lord. The Lordship found that it was not necessary to debate it because of the finding. But that's really all that Porrit said. But Porrit did not say that you may not raise issues of bias in the context of 106H. In fact, it said the exact opposite at paragraph 17. But this does not mean that a prosecutor can never be disqualified on grounds of bias or apprehension of bias, where his or her bias affects the accused's right to a fair trial. A prosecutor may well be disqualified. And the court relied on Smythe. You'll remember one of the cases we had debated versus Ushe Okunze. So that's just another reason why this case, as your lordship indicated earlier, would be a prime candidate to go to the SCA, because they might then get an opportunity also to clarify what the SCA meant in Porrit, which with the greatest respect we submit is not what was found here. And in any event, even the SCA might not be the last word, because this is a complex area of law, which unfortunately has not yet, the 1061H part has not yet been decided. Apropos the so-called wide or narrow interpretation, which of the two interpretations? Of course, we contend for the narrow, or rather for the wider interpretation. Your lordship adopted the narrow interpretation. We accept that, but all we have to say at this stage is that another court might well agree with us that with the application of section 39(2), the wider interpretation is the correct one. As the court pleases, we're indebted to the court, my lord.
Thank you.
I'll hand
Is
over
Mr.
to
Masuku
Mr.
still going to address me? Yes, okay. Masuka, have you reached some agreement with the other side, with the state, on time?
My lord, we did not speak, but
Well, how long is your address going to be? Let me just see on that.
if I'm not interrupted, my lord, it's 30. I'd say 30 minutes.
Well, it depends how cogent your arguments are. 30 minutes, okay. You happy to fit in with that, Mr. Breitenbach?
My lord, I'd in fact agreed with his leader that they would end at 12:15, but I will live with him.
Yes, all right. Thank you.
My lord, I intend to deal with the issues that my learned friend Mr. Mpofu has not dealt with. The first one being the meaning that the court attached to section 108 of the CPA, and in that regard refused to conduct a trial of the plea that had been handed down. That had been raised by Mr. Zuma at the commencement of the trial. The second issue, my lord, would be that your lordship found that you couldn't deal with the arguments, or rather the removal of Mr. Downer, on the basis that there was no application to have him removed based on bias or the lack of independence, and that the procedure we had adopted somehow was not sufficient for the court to have dealt with that issue on the pleaded grounds. Then the third issue that I need to deal with very quickly would be the impact of the SCA judgment. But I mean, that has already been addressed in a way by Mr. Mpofu, and so I don't intend to address that. But the impact of that, just to start there maybe, is that if this matter were to go back to the SCA would probably be surprised, because it would say to us the facts on which we regarded as speculative, the facts which were pleaded by the NPA, the allegations made by the NPA, of criminal conduct by NPA officials, of prosecutorial misconduct by NPA officials, to the knowledge of Mr. Downer, have not been tried. They remain in the same state that they were here prior to that. They remain as they were when the matter was last heard by the SCA, and so the appropriate procedure, which we contend is a fair procedure to have adopted, would have been to subject the plea to a trial with reading of oral evidence and with the right to cross-examine. As it stands, all the allegations made in Mr. Hofmeyer's affidavit have never been tested in cross-examination, never been subjected to trial. The NPA has not been held to account for what they say they did in the prosecution of Mr. Zuma. They tell Mr. Zuma in an affidavit, this is what happened in your case. People interfered with your case. to the knowledge of Mr. Downer, people did all these things that are set out in the affidavits. And obviously Mr. Downer did nothing. In fact, Mr. Downer says in his affidavit, subsequent affidavits, in the permanent stay and this application, no, these factors, these allegations of criminal conduct by the NPA officials are insignificant in the fair trial rights of Mr. Zuma. But well, we would like to cross-examine those observations. Like Mr. Zuma would like to know a bit more than just the view that, the theoretical view that these have no impact on Mr. Zuma, because they have real impact on him. Mr. Zuma would have liked to tell the court what impact these allegations by Mr. Hofmeyr has had on his political career, on his social standing in society. There is incredible prejudice that President Zuma has suffered as a result of the allegations that are contained in Mr. Hofmeyr's affidavit. And we submit that a Section 108 procedure, in terms of which this plea of Section 161H had to be tried, should have been followed for exactly that reason, that the trial court was not entitled to reach the conclusions that the SCA reached. For example, that the evidence or the facts or the allegations of Mr. Hofmeyr were speculations. It was not entitled. You can't come to the conclusion that these are speculative allegations when a member of the NPA, a senior member of the NPA, says, no, we were wrong. And I will take your lordship to just one paragraph where Mr. Hofmeyr comes out very strongly and says, we thought that we could leave this to a permanent stay application. And when we looked at the allegations, we thought, no, we can't do this, because we have a duty as an NPA when such egregious violations of prosecutorial conduct have occurred. We have a duty to protect the image of the NPA. It doesn't matter what the consequences are, whether people are arrested or people are fired from work, it doesn't matter, we're going to do it. But here we are. Mr. Downer doesn't believe that any of those allegations made in Hofmeyr's affidavit are allegations that impact on fair trial rights. Your lordship accepts that argument, goes ahead and accepts the argument that the facts on which the allegations made in the affidavit of Hofmeyr are in fact speculation, they are hearsay, all sorts of words that seem to suggest that they are insignificant in the scheme of things. Well, but the court was not entitled to do so without having conducted a proper trial of those facts. By doing exactly what the SCA did, the court essentially moved away from what the SCA had in fact directed that it be done, which was to ensure that these allegations which were raised by Mr. Hofmeyr as a basis for termination of prosecution be tried in a court of law. They are not going to go away because the NPA does not want to deal with them. Those allegations are egregious in how they characterize the conduct of the NPA itself. And my lord, in your judgment with respect, there's not a single reference that I could find where your lordship went and looked at went and quoted from the affidavit of Mr. Hofmeyr to show what kind of misconduct, what kind of criminal activities were involved in the prosecution of Mr. Zuma by the NPA. And that has to be important because it is trite. A complaint of this nature that that there's been criminal misconduct in the prosecution of an individual ought to concern the courts. It ought to horrify the courts that the prosecution is defined in the terms that Mr. Hofmeyr has defined the prosecution of Mr. Zuma. It should not just be wished away. Mr. Zuma should not have to suffer the indignity of a cooked up prosecution. And I say cooked up because this is what the NPA itself says. There was manipulation of the prosecution for political reasons. But it is in the detail of that the court simply ignored. And had the court decided that they were going to, they would subject this to trial, the NPA at the very least would have had to account for what is contained in their own affidavit that is pertinent to whether or not fair trial rights have been affected in this particular case. There is a dispute within the NPA itself in the first place. There is a group in the NPA which is led by Mr. Hofmeyr and supported by the others who believe that their unfair trial rights have been affected. There is another group that is led by Mr. Downer who believe that unfair trial rights do not arise. Mr. Zuma can perfectly have a fair trial in circumstances where Mr. Hofmeyr himself says in paragraph, and perhaps I should read in paragraph 240 of his affidavit, in page 240 of his of the record, and paragraph 275. He says, I argued that the prosecution should be discontinued. This is a senior member of the NPA, very senior to Mr. Downer. Says, I argued that the prosecution should be discontinued. I had investigated Zuma's allegations. In my view, they proved that McCarthy and Nuga had actively abused the NPA to discredit Mr. Zuma. Their motive for doing so was political. They believed that it was acceptable to use the NPA to assist Mbeki in his factional battle against Mr. Zuma. I felt that it was important to expose what they had done. I felt it was important for the NPA to send a clear message that the political interference in the work of the NPA would not be tolerated and would be exposed. Now, these are the people with this constitutional responsibility to ensure or to safeguard the integrity of a prosecution. This is what it tells the court. It says it was a grave intrusion into the workings of the NPA with the effect that Mr. Zuma's fair trial rights were affected. Mr. Downer doesn't believe they are affected. But we can't resolve that issue on papers simply because the Supreme Court of Appeal found that Mr. Downer was right, that the determination of prosecution was incorrectly done. The facts on which it was alleged that the prosecution of Mr. Zuma would result in unfairness by the NPA itself must be a matter for trial. 108 should have been utilized because that's the fairest way of getting to the bottom of the matter. If an accused person complains that an unlawful act has occurred or criminal act has occurred in their prosecution, it is the duty of the court to first decide that question. Decide firstly the question whether or not there has been criminal conduct in the prosecution of an accused person who has made complaints of that nature. And you do that by conducting a criminal trial. And that trial would involve members of the NPA who are cited, who are referred to in this affidavit of the NPA, the very institution that seeks to prosecute Mr. Zuma, says we did wrong, but Mr. Downer thinks differently. And it is Mr. Downer's view that finally passes, that finally wins. But it cannot win the day without first resolving the fundamental questions of whether or not the conduct alleged by Mr. Hofmeyr in his affidavit is correct. Because if these allegations are correct, my lord, essentially what happened here was that this is a manufactured criminal trial. It was manufactured for political reasons, and you have to find out in a trial conducted with oral evidence being led whether or not the rot, where the rot goes to. Where does the political interference go to? Does it go into finding allegations that are flimsy to put up simply to discredit politically? Where has the rot gone? I mean, in fact, you don't have to go far, my lord. The affidavit of Mr. Hofmeyr says it all. And you can read paragraph 276, which also says, he told us that listening to the recordings had made him angry. He informed us that he could not go on with the case and that he had decided to drop the charges. In other words, to discontinue the prosecution. This is a senior member of the NPA saying, you know what, I looked at this thing. It's like yourself, my lord. If, for example, there were to be an interference with your work, you'd be very angry with that. And you'd say, no, but I can't tolerate anybody interfering in my work. You'd have to stop it. If it's criminal interference, you'd have to report it to the police and have the police investigate it. And whatever investigation is done, the person who interferes with your work must pay the price. And this is what we're asking. Before you subject Mr. Zuma to the trial that Mr. Downer wants, ask the question, does the NPA or has the NPA made allegations? And these are not people with no knowledge. These are people with resources and knowledge. These are experts in criminal law. These are they run the very machinery of prosecution. They tell the court something was wrong in the way we conducted this issue. Or Mr. Downer says, no, it is not. It will not impact on the fair trial. And the court then endorses a position where these allegations of impropriety, involving the NPA, will not be dealt with. At what point is the NPA held responsible for violating its own code of conduct, its own statutory responsibilities insofar as it must conduct a trial, a prosecution independently, fairly, within the law? And this goes to the heart of what we argue should have been the meaning of title. Because there is no title to prosecute under these circumstances. And this is where, my Lord, I must take your Lordship to the title itself. The title itself is actually in the documents. And again, the court did not refer at all to the title that is set out on page, it's page 1008 of the record. And you'll see, my Lord, there that Mr. Downer put his authorization from the NPA, and it says that authority to institute and conduct criminal proceedings, I, Moipone Nuku, Director of the Public Prosecution for the area of jurisdiction of the High Court in South Africa, KwaZulu-Natal Division, duly designated by the National Prosecutor in terms of Section 25, hereby authorize William John Downer to exercise on behalf of the Republic the powers mentioned in Section 20, 1A, B, and C of Act 32 in all courts within the Republic, and the case is cited there. That's the first thing. If you flip the page, you'll see there that there's also Elaine Zuma's authority, which gives Mr. Downer the authority of the authority to prosecute. But there is an addendum to that authority, and Roman numeral 3 of that addendum says the authorization is of no force and effect until the holder takes the oath affirmation provided in Section 32(2) of Act 32 of 1998. Of course, we don't have Mr. Downer's oath of office in the documents, but we take it probably is there. We don't quibble with the fact that it's there. But if you go to the oath of office itself, and you'll see, if you flip on the next page, which is 1612, and that's the oath of office which Mr. Downer would have taken, which is taken under Mr. Kelvin Llewellyn Singh. It says, and this would be, the full names of Downer would be William John Downer, do hereby swear that I will, in my capacity as prosecutor, uphold and protect the Constitution and the fundamental rights entrenched therein, and enforce the law of the Republic without fear, favor, or prejudice, and as the circumstances of any particular case may require, in accordance with the Constitution. So the requirements of, I'm almost done.
No, it's fine.
My Lord, I did say 30 minutes, and I am done. I can see you're looking at the watch. But I don't know whether that's an impatience to show me that I must do, but
no,
I'm making a very important point.
I was just checking. What is the page number that you're referring to?
No, it's page 1612.
1612.
I'm making an important point.
Yes.
And when I make an important point, and then you look at the I mean, it tells me that am I done?
Mr. Masuku, I was purely looking at how the day is unfolding. I'm not putting pressure on you on that respect.
No,
Please,
when you look at the watch, it's putting pressure on
Yes, I did look at my watch to see what time it was left.
Yes, but I'm conscious of that, and my leader here is looking at the
Mr.
time.
Masuku, let's move on. We're wasting time now,
okay.
please.
Okay, but anyway, the point I'm making, my Lord, is this: if you look at the authorization itself, it mentions the very principles on which we said he doesn't have title. The principles on which we said expand the meaning of title to include loss of title on the basis that he can never prosecute in terms of the law. He cannot prosecute, but it cannot uphold the law and protect the Constitution. He can't do it because, my Lord, he has a duty when faced with these allegations to make sure that the NPA purges itself of these allegations before he can come to the court and say Mr. Zuma will have a fair trial. If he contests that there's going to be a fair trial, then what he must do is he must accept that the allegations made by his boss in the NPA, which are very serious allegations of NPA criminal conduct, must be subjected to a trial, in which evidence will be led, cross-examination will be done. Your Lordship dismissed some of these allegations, speculation as unfounded, and without any cross-examination being done, without anybody having asked Mr. Downer, why do you think this is Mr. Hofmeyer says that there were spooks involved, foreign spooks involved in the prosecution of Mr. Zuma or in the investigation including Mr. Zuma. Why do you think this does not have impact on his fair trial? We would like to know. It's simply not sufficient that that is answered via an affidavit and it's decided by the court on paper. Finally, my Lord, on page 165,
Page 165.
sorry, so I'm trying to okay, no, I took the wrong. On page 286, paragraph 512. There were allegations that the NPA was trying to, in fact, when the DA reviewed this particular termination of prosecution decision, it alleged that the NPA was trying to hide some things. And the response of the NPA is that we're not trying to hide anything. As pointed out above, Mshe and his deputies were so alarmed by evidence of political interference in the affairs of the NPA that they recommended that a judicial inquiry be established to investigate the matters further. Of course, that was not done. And then on page 165 of the same affidavit, on paragraph it's page 165 of paragraph 23. We made the allegation that the NPA under Hofmeyer said that the gravity of political interference was such that it was clear that the prosecution was being directed from not within the NPA but from outside. And paragraph 23 says, until he listened to the recordings myself, and this is Hofmeyer speaking, says until he listened to the recordings himself, Mshe had been unaware of how deep McCarthy's association with Muga still was. Most senior members in the NPA, including Mshe, knew that McCarthy and Muga were still friendly. We were aware of the extent to which Muga, using McCarthy as his proxy, was involved in directing the Zuma prosecution and possibly other investigations and prosecution. It was Muga, working with others, and not McCarthy, who ultimately decided when Zuma should be charged. That's a member of the NPA. Why is the court not wanting that to be subjected to a trial? Why should the rot that is set out in Hofmeyer's affidavit, which clearly shows that there's been criminal conduct by members of the NPA to the knowledge of Mr. Downer, be simply swept under the carpet? Because we say that a fair trial would require that those allegations are investigated, and Your Lordship, after oral evidence has been laid and has been tested and everything has been tested, you can come to the conclusion that that's speculation, that's irrelevant, that is. But before that, with respect, my Lord, that is not fair that Your Lordship decided to decide this matter on the basis of affidavits, and it's completely incorrect that Mr. Zuma never raised the issue of wanting oral evidence being laid. I do recall that I raised it both here in both in Your Lordship chambers and here in an open court, that this plea had to be, we would be asking at some point that it be tried orally or it be tried through leading of evidence. In fact, it was also raised in our reply, but it was raised in our reply because what then happened is that the NPA completely denied every allegation on which we sought to persuade your lordship to extend the meaning of title to mean that lawful title. In other words, the authority of the NPA to conduct a lawful prosecution. When you've been a witness of such grievous allegations of criminal conduct involving a prosecution, can't be suggested that you still carry you should still carry my learned friend, Mr. Trenkov, argued previously, that there should be a reward given to Mr. Downer because of his exceptional work. He is a witness to criminal activity within the NPA. But that has not been tried. And we ask your lordship that another court may direct in very specific terms that this court gives this plea the trial that it deserves, which will serve a number of reasons. It's in the interest of justice to do so. One of them is to ensure that the accountability of the NPA in ensuring that a clean prosecution has been done is achieved. The second one is to assure the public that the NPA's conduct is as serious to the courts as it is to everybody else. When allegations of criminal misconduct has been laid against the NPA members, to the knowledge of the prosecutor, those must be dealt with firmly before any criminal accused is put through a trial.
A trial.
Those are my submissions, my lord. I apologize if I exceeded the time.
No, can we check?
My lord.
Can we check now?
No. You are. I think I exceeded maybe by 2 minutes.
Mr. Masuku, that's on a light note, and you made it with a minute to spare, I think.
No, thank you, my lord.
Are those your submissions?
For your accommodation.
Yes, thank you, Mr. Masuku. Mr. Bradenmer?
Thank you, my lord. May I too remove my mask for?
Yes, as long as you're comfortable with it. I don't know that I can really grant the authority, but there it is.
I'll take my chances. It's hard to speak through the mask. Thank you. My lord, we shall address the 4 applications brought by the first accused in the order in which they are dealt with in his heads of argument, and shall attempt to confine our oral argument to the main points on behalf of the state. The first issue then is the alleged irregular procedure in the application for leave to appeal. As the court knows, Mr. Zuma contends that the court committed an irregularity when it directed that the state deliver an answering affidavit and he deliver a replying affidavit in his application for leave to appeal. And his point was that no statute or rule of court makes provision for such affidavits. Now, we've heard this court's elucidation this morning of its directive regarding the filing of answering and replying affidavits. At the time, we misunderstood it. We thought it applied to both the application under Section 3161 for leave to appeal and the application under Section 365.
Sorry, just give me a moment, sorry. Yes, Mr. Breitenbach, I've just been told that you're speaking quite softly, so you must move right in front of a microphone, not a press microphone, but a court microphone. Perhaps is that thing's on wheels? Well, then just move it up, please.
Thank you.
Sorry to have interrupted you, but please continue.
I'll start again for the...
I've said, you said it was misunderstood,
Yes.
and obviously in the fullness of the judgment, I will set out the verbatim wording of the letters,
Yes.
and it can then be decided whether it was a justifiable error or not. But yes, the state also proceeded on that basis.
No, we accept that we have misunderstood it as applying to both applications, the 316 application for leave to appeal and the 3165 application for leave to adduce further evidence, and not just the latter. But we submit that this court's elucidation, which my learned friend Mr. Mpofu accepted this morning, removes Mr. Zuma's cause for complaint, because it's a complaint against the court. and the court has now explained what was meant. From a practical point of view, what it means for Mr. Downer's affidavit, this is now his answering affidavit that was filed in December, is that it is admissible only insofar as it deals with the 3165 application for leave to adduce further evidence. In other words, paragraphs 48 to 63, which are at pages 64 to 69 of the record for purposes of today's proceedings. Lastly, in this connection and in any event, we submit that the state's delivery of an answering affidavit in the 3161 application for leave to appeal did not prejudice Mr. Zuma. On the contrary, it facilitated the early identification and delineation of the issues in dispute. In the period since mid-December, when the state's answer was delivered, Mr. Zuma and his legal team have had ample time and a proper opportunity to respond to the state's points. Lastly, those points have now been repeated in the state's heads of argument, against which no objection is taken by the other side.
Yes.
That then brings me to Mr. Downer's alleged conflict of interest. Mr. Zuma alleges that Mr. Downer should not have deposed to the state's answering affidavit in the application for leave to appeal or the application to adduce further evidence because the special plea in terms of 1061H concerned him, but related, in other words, to him. Now, we deal with this issue in our heads at pages 6 to 7, paragraphs 13 to 16, and we make three submissions. In brief, they are the following. Firstly, Mr. Downer is best placed to answer the allegations concerning him in these proceedings. We make this point in our heads at page 16, paragraph 15, where we submit as follows. Mr. Downer made the state's answering affidavit in response to the special plea, without demur from the first accused. Doubtless, the absence of any objection to his doing so was because, as the person best placed to answer the welter of allegations against him, it was obviously right that he deposed to that affidavit. There is no good reason why a different deponent should make the state's answering affidavit in the application for leave to appeal against the dismissal of his special plea. Our second submission is that, far from having a conflict of interest, he has an identity of interest with the state. In other words, the state opposes the relief sought by Mr. Zuma on the same grounds, which are set out in Mr. Downer's affidavit, but which, as we've said, is not, that part of his affidavit is not admissible anyway. What is admissible is his opposition, grounds for opposition to the 3165 application. And the fact that there is an identity of interest between Mr. Downer, what he said, and what the state says, appears from our heads of argument. We have submitted those heads of argument on the behalf of the state, and there's no point taken that they were not, and that this oral argument today is not being adduced to you on behalf of the state. The last point is that Mr. Downer has been designated by the DPP to conduct the prosecution of both accused and to carry out any functions incidental to the prosecution. My learned friend Mr. Masuku read from that designation today. We submit that deposing to the state's answering affidavit in these proceedings is a function incidental to the prosecution. The state is entitled to select the deponent to its answering affidavit. That then brings me to the first big point for decision in this matter, and it relates to our contention that Mr. Zuma has no right to seek leave to appeal to the SCA. We understand them to have abandoned the application insofar as it relates to the full bench, under Section 316(1)(a) of the Criminal Procedure Act, unless and until he has been convicted and sentenced by this court. Now, our argument here has 4 building blocks, and they are the following. The first relates to the wording of Section 316(1)(a), which deals with appeals from the High Court to the SCA. It provides in paragraph A that, and we quote, any accused convicted of an offence by a High Court may apply to that court for leave to appeal against such conviction or against any resultant sentence or order. Our second point is that although Mr. Zuma's special plea in terms of Section 1061H of that statute has been dismissed by this court, he has not been convicted of any offence by this court. On the contrary, in its judgment, the court concluded by directing that the trial of the accused on their pleas of not guilty to the criminal charges preferred against them by the state must now proceed. At the conclusion of that trial, Mr. Zuma will either be acquitted or convicted. The third point concerns the interrelationship between Chapter 31 of the Criminal Procedure Act, that's Sections 315 to 324, and Chapter 5 of the new-ish Superior Courts Act, that is Sections 15 to 20. Our contention is that Section 3161 and other related provisions, notably 315, in Chapter 31 of the Criminal Procedure Act, deal expressly both with the circumstances and with the manner in which an accused in a criminal trial in the High Court may appeal to the SCA. As a result, we submit those provisions are not supplemented by Chapter 5 of the Superior Courts Act, the chapter dealing with appeals generally. It regulates, as the court knows, amongst other things, appeals from the High Court. On the contrary, we submit appeals by accused persons in criminal trials in the High Court to the SCA are expressly excluded from the ambit of Chapter 5 of the Superior Courts Act. And that is due to the definition of the word appeal in Section 1 of the Superior Courts Act, which provides that in Chapter 5, unless the context otherwise indicates, the word appeal, and I quote, does not include an appeal in a matter regulated in terms of the Criminal Procedure Act. And we submit the correctness of these propositions can be tested by comparing the facts of the present case with the facts of the leading constitutional authority, Leashing, S.V. Leashing, L-I-E-S-C-H-I-N-G and others, 2017, 2 SACR 193 Constitutional Court. It's number 5 in our bundle at pages 18 to 27. In the present matter, we contend Section 316(1).
It's a different factual scenario.
Completely different.
Leashing deals with an appeal in respect of the refusal by the President of the Supreme Court of Appeal to refer a refusal of a petition for consideration by the court, the SCA. Now, it flows from, I think it was Jacob J. and Chwala. Or it might have been, no, I think it was Musi A.J. in the previous leashing matter. Yeah, that's correct. Saying that the provisions of Section, of the Superior Courts Act and also the Criminal Procedure Act, they are comprehensive but not exhaustive.
Yes.
It was Musi A.J.
Yes.
And it's for that reason that, because 316 doesn't deal with an appeal post what would normally be the final step in the criminal judicial process. That is where where two judges of the Supreme Court of Appeal have refused a petition, and the President then refuses to have that reconsidered. That is something not catered for in Section 316 or 317 or whatever that chapter is, Chapter
31.
of the CPA, and one can understand that. We're not dealing with that situation. We're dealing with a situation pre-conviction. You understand your argument that it's 316, and I think 315 also deals with it, that it requires, there's no appeal until conviction, and then in respect of conviction, sentence, and any incidental orders or something like that that the section speaks of. Does that exclude, though, taking into account that the provision is comprehensive but not exhaustive, the situation like, for example, a special plea on jurisdiction that, let's for argument's sake accept, was rejected for totally the wrong reasons, which brings us back more to whether it would be in the interest of justice that an appeal be pursued at that point, which almost smacks of Western areas and what Howie P. said there. But the problem with that is that, well, not the problem, although the court there didn't act on it, Howie P., the President, said that the legislative authority for that is Section 21(1). Now, it seems to me that in Lishing, the basis upon which the court proceeded was that the word, quote, decision, unquote, in Section 17 of the Superior Courts Act would include the kind of decision that the President of the Supreme Court of Appeal had taken. Now, couldn't that interpretation be extended to also include, for example, a special plea on jurisdiction, notwithstanding that prima facie still forms part of the trial, i.e. pre-conviction, and therefore not expressly within the provisions of Section 3161A. That's really the crux of the issue, isn't it?
On this particular issue,
Yes.
I do agree that you've put your finger on it with respect, my Lord. May I suggest that we approach the matter this way?
Yes.
There are three important cases. The first one is Western Areas, which was decided in, let me get the date precisely correct, on the 31st of March,
somewhere around there.
31st of March 2005.
5.
The second is the case referred to by my learned friend, Mr. Mpofu, this morning, the 2007 Basson judgment.
Case.
And that case concerns Section 319, not 316. And the third is the Constitutional Court's judgment in Lishing, which is in 2017. Now, as your Lordship pointed out, at the time when Western Areas was decided, we were in the regime of the old Supreme Court Act of 1959, and Section 21 sub 1 of that Act conferred on the Appellate Division, then Appellate Division, SCA, authority to hear appeals generally in addition to any authority conferred on it by other statutes. No such provision is to be found in the Superior Courts Act, and in fact the Superior Courts Act goes the other way by generally excluding from the ambit of Chapter 5 the appeals provision, appeals which are dealt with or regulated by the Criminal Procedure Act or any other criminal procedural law. So, what does one make of that? Well, we submit, my Lord, that the provision in the Criminal Procedure Act which caters for questions of law which arise at any stage in criminal proceedings is Section 319. 319.
Yes.
So if a dismissal of a special plea, or indeed the upholding of a special plea concerning a court's jurisdiction, turns on a question of law, that question can be reserved for the consideration of the SCA under Section 319. Equally, if the upholding or dismissal of a special plea under Section 1061H concerning title to prosecute turns on a question of law, that question may, in the discretion of the trial court, be reserved for the consideration of the appellate division. There is no need to try and shoehorn an intermediate appeal, such as the one which has been sought in this matter, into Section 316, if the question is one of law. And if I may go to the end of my submissions, I said I would deal with them in the order in which we deal with them in our heads of argument. But as the court knows, we contend that, and have always contended, that Mr. Zuma's special plea under Section 1061H is excipiable on its face because the grounds raised in support of it do not relate to the word title properly construed in Section 1061H. Mr. Zuma's response to that, his counsel's response to that, is to contend that title should not be interpreted in the manner for which the state has contended. In essence, they contend, in the main, that Porritt's case was wrongly decided and that it bears a wider meaning. That's a question of law. We accept that. If one looks at our heads of argument, we don't contend that an application under 319 would be incompetent at this stage. In other words, there is no jurisdiction. Such an intermediate appeal is not viable. We accept that insofar as what is raised is a question of law, this court does have a discretion to refer it. But we will, and I'll deal with this in more detail when I get there, we say three things about that application. The first is, it is clear from the authorities that such a referral will not be made where there are no reasonable prospects of success. And as I shall elaborate in a moment, there are no reasonable prospects of successfully persuading the SCA that Porritt was wrongly decided. The second is, it's a discretionary power which is conferred on this court. And obviously one of the factors that will be considered in the exercise of that discretion is the interests of justice. And I shall deal with the various reasons why we submit that an appeal at this juncture would not be in the interests of justice, and indeed would be contrary to the interests of justice. And the third is that Section 319 is there to allow a High Court to refer to the SCA for its consideration and decision, a question of law which it has not already decided. It doesn't say so in terms, but that must be the purpose of the provision. In this instance, we are dealing with a question of law which the SCA has decided. In Porritt's case, the proper meaning of title. And so,
well, they say it should be reconsidered. But should I, is it this court's function to assess that? Or is it this court's function to look at it and say, according to our principles of stare decisis, court is bound, even if I might disagree with it? And if it's to be pursued further, then ask the SCA by way of a petition whether it wants to deviate from its previous decision.
And that, my lord, is the last thing I wanted to say. That brings us back to the relationship between 319 and 316. The fact that the court refuses to refer a question to the SCA for consideration at this stage doesn't preclude the defense, if the accused is ultimately convicted, from raising the point as a ground of appeal. It will obviously have to seek leave to do so, just as in essence it seeks the court's leave for the referral of the question at this juncture. So that, my Lord, is how we see these three strands of the law fitting together. It is a little complex because of the change in the general statute regulating high courts, the Supreme Court Act being repealed and the Superior Courts Act being put in its place.
Yes, my earlier comment really referred to that whether Porridge is to be followed in the future, the appropriate entity to ask is the Supreme Court of Appeal by way of petition.
Yes. And it,
because as things stand at the moment here, if I consider it on all fours, I'm bound to follow it. I don't have an option,
yes,
as the full court would have.
hence the abandonment of the appeal.
And in
to
fact, the
full court.
SCA doesn't have a full, a carte blanche authority. It must be satisfied that its previous decision is wrong.
Clearly
But that's a call that it would have to make.
Yes, clearly wrong, my Lord. It's a
Clearly
higher
wrong.
standard.
Well, that's Camps Bay case, isn't it?
Yes.
Yes.
Otherwise, the doctrine of precedent will be upended, and that there are various legal interests which would be adversely affected by that open-ended consideration and reconsideration of questions. So, my Lord, may I just then briefly finish the argument on 3161A? So what we essentially agree with your Lordship. The essence of the distinction, I'm just looking at leashing on the facts. May I commend to your Lordship on the law, the most important paragraphs in the leashing judgment are all on page 23 of our bundle. They are paragraphs 23. They're paragraphs 36 to 44. And later in the judgment, His Lordship applies the law as stated there to the facts. Let's just start with Leashing's case. Leashing, unusual factual situation. Three people were convicted of murder. It seems the evidence of one witness played a big role in that. They were sentenced to lengthy periods of imprisonment, and then a fourth person was tried separately from them.
I've read the judgments, both of them.
And he recanted the evidence that he'd given previously. Unfortunately for them, by that time, they had applied unsuccessfully for leave to appeal in the High Court, and their petition to the SCA had failed. They asked the President of the SCA, under the proviso to Section 17(2)(f) of the Superior Courts Act, to refer their petition back to the judges who received it for reconsideration, because it was essentially now a petition for something different, for an appeal in which they would seek the leave of the SCA under Sections 316, 12 and 13 of the CPA to lead this further evidence. And the President said no, they'd reached the end of the road as far as that proceeding was concerned. They had to use Section 327 of the Criminal Procedure Act, which caters for this situation but allows the Minister of Justice to refer the matter to the court, which will then hear the evidence, and if the court believes that the result would have been different, to then make a recommendation to the President for the exercise of his or her prerogative as to pardon, etc. The CC approached the matter on this basis. It said the Criminal Procedure Act procedure had run out. There was no further appeal. The Section 327 process is not an appeal. It is a process which may or may not result in a pardon being granted by the President, by the Executive, by the person in his capacity as Head of State, actually not the Head of Executive. And it's in those circumstances that Chapter 5 supplements the procedure in the Criminal Procedure Act. And as I've endeavoured to explain, our Criminal Procedure Act has provisions which deal with, firstly, when an accused may ordinarily appeal, and secondly, with the reservation of questions of law at any stage in the proceedings, not just at the end of the proceedings, so says Mason's case in 150, para 152. And so we do have a procedure under which hasn't run out. So the real application before you today, we submit, is a Section 319 application, not a 316 1A application. You may ultimately, if Mr. Zuma is convicted on any of the charges against him, be faced with a 316 application in which the leave to appeal is sought against the dismissal of his special plea. That's assuming your Lordship doesn't exercise the 319(1) power in their favour in the meantime. There was some reliance placed on Section 3530 of the Constitution as an alternative basis. My learned friend argued it orally this morning. That provision, as the Court notes, provides that every accused person's right to a fair trial includes the right of appeal to or review by a higher court. That's the wording used. But as your Lordship mentioned, in Twala's case, 2000 Volume 1, SA 879CC at paragraphs 9 to 11, the Court interpreted that provision in a way which makes it clear that it applies only to appeals against a conviction or sentence. So we submit that Section 3530 of the Constitution doesn't provide
the paragraph numbers again? Sorry, I didn't make a
So
note.
it's paragraphs 9 to 11 of Twala. They're in our bundle
Yes, no, I've
at
read it.
pages
Thank you.
41 to 42. Now, assuming, my Lord, that you're against us on our primary submission, and what I'm now going to say also relates to the exercise of your Lordship's discretion under Section 319 in relation to the request for the reservation of a question of law. In both instances, the following question arises. Would an appeal at this juncture be in the interests of justice? And we accept that your Lordship will have to get to that question insofar as what is being sought from you is a request for a referral to the SCA for a reconsideration of its decision in Porritt, specifically Para 7 and Para 8, as to the meaning of title in 1061H. Here, the Western Areas case is, we submit the leading authority, and specifically paragraphs 34 and 35. That's authority for the proposition that a decision which doesn't have the effect of disposing of a substantial portion of the release claimed in a criminal case should be taken on appeal intermediately, only if the interests of justice in doing so, in the particular case, outweigh the considerations which underlie the general rule against piecemeal.
Was that now,
appeals.
I was not clear on what was being conveyed there. Does that now deal with an appeal that doesn't meet the test in Zweni?
Yes. If one looks at those
If it's,
yes.
yeah, if it doesn't meet the test in Zweni, then it's really interlocutory in nature. And normally wouldn't have been appealable.
Yes. I hesitate to say this is interlocutory,
Well, sorry,
but it's not
it's midstream.
Yes.
Perhaps I should rather use that word than
Yes.
a phrase that is more appropriate in a civil context.
Yes. So that is what Justice Howie was saying. He said that Zweni is not the law of the Medes and Persians. Even if one doesn't meet those requirements, there may be circumstances in which the interests of justice, it's in the interests of justice to allow the losing party on this intermediate question to go on appeal. And my learned friend, Mr. Mpofu, has relied heavily on the part of that judgment which says where the result would be to put someone to the trouble, expense, stress, etc., restrictions on their liberty of a criminal trial, when ultimately it may turn out that there was no good reason for doing so.
Now, if such a question arises, and it's not a question of law, but one of fact, does that mean there can't be an appeal, even if it would save an accused suffering the expense and the stress and the hardship and everything of going through a lengthy trial?
May I answer the question this way? The only way in which, there are two ways in which that can be addressed. If it's an appeal to the SCA, this court would have to interpret and apply Leashing's case as meaning in the paragraph to which I referred you on page 23. The first of the one which talks about supplementation. Supplementation, in other words, by Chapter 5 of the Superior Courts Act of what's in the Criminal Code. Interpret that widely to cover any situation which is different from the way things are done or regulated by the Criminal Procedure Act, rather than, as happened on the facts of that case, to fill a gap. In other words, the road had been reached, the end of the road had been reached for Mr. Leashing as far as appeals were concerned, and the court said, that's under the CPA, yes, but there is this power inherent in the President of the SCA to refer the petition back for reconsideration. So that's where the supplementation
To fill a
comes
gap,
in.
you say?
So
Now,
your Lordship would have to interpret the Superior Courts Act as supplementing the Chapter 31 of the CPA by allowing appeals in media res, in the middle of the case. We've argued against that. We say that the CPA deals sufficiently with it by allowing questions of law to go forward in the meantime, but not questions of fact. Those must wait until the end of the trial. But the argument I'm now advancing in relation to leave to appeal, as opposed to the application for the reservation of a question of law, is in the
Yes.
alternative to the submissions that I've just made.
I've understood your question of 319 obviously would apply only if there's a question of law involved.
Yes.
But you're saying, well, if leashing is interpreted that way, to fill a gap or to supplement the Chapter 31 situation, and what would govern?
Well, then
What would govern that interpretation? Would it be? Are we back to Western areas, whether the interests of justice require it? Is it discretionary? So it's not precluded, but whether it should be granted depends on my discretion in deciding, yes, it's appropriate because it is such a fundamental issue that could save a long trial, etc.
Applying the approach in Western areas, and this is, if I was in your Lordship's shoes and inclined to go that way, this is how I would approach it. I would say that the principle that I abstract from leashing and from Western areas is that Chapter 5 of the Superior Courts Act supplements the appeal provisions in Chapter 31 of the CPA to allow an intermediate appeal, even on questions of fact or mixed law and fact, or it could have all three variants, where it is in the interests of justice that be done. That was essentially the bottom line of Justice Howie's judgment in interpreting and applying the very wide provisions of Section 21(1) of the old Supreme Court Act. He says what those wide provisions mean is that you can have intermediate appeals where the interests of justice, where it's in the interests of justice that happen.
Because as much as it might be appealing on a sort of a clean break, the notion that there's no appeal at all ever prior to conviction is quite a jump to make in logic.
Well, it's,
yes. It was there on Section 21(1). It was there on Western areas. Cases have always said appeal shouldn't, or criminal trials shouldn't be disposed of in a piecemeal manner. 2008, round about there, the very strong comments by Langer, CJ, in Tint were expressed then at that stage already, the Superior Courts Act, I think, was in the process of being considered. The bill was. And I've tried to look at the history of it. It seems the definition of appeal only was introduced at the Justice Portfolio Committee stage. So it came quite late.
I was not aware of it.
Yeah, well, if my research is correct, as I say, I've had limited time. I've just been scratching around. The question then is whether, by that introduction of that definition of appeal, which didn't exist in the in the Supreme Court Act, quite a drastic new dispensation was being contemplated for appeals in criminal matters. But it's not surprising that a new dispensation, if you like, in criminal appeals was being contemplated and was sought to be introduced, because it fits in, if I can use some old terminology, with the mischief that Langa CJ was talking about in tint, in the interim. And that's not even going back to Rosley and what Murray J said and in those cases, because the principle has always been piecemeal appeals or piecemeal disposal of criminal matters should be avoided.
Yes. So that principle remains. And my Lord, you asked me what would the legal basis be for the general possibility of a general appeal, not just appeal on a question of law prior to conviction.
Yes.
I submit it would be
Is it a lishing, section 17.2F?
It would, no.
What?
It would be rooted in the principle in leashing, which is specifically in paragraph 36, which I think I must take your lordship to, that the function of the Superior Courts Act is to complement and supplement the CPA. Our argument is, as the court knows, is that is where there is a gap, and that we don't have a gap here, and we certainly don't have section 21.1 of the old Supreme Court Act. But the argument against it, and it hasn't been fully articulated, but this is a question of law, and in fairness I must articulate as best I understand it the argument against the position which we've adopted, and it's rooted in paragraph 36.
Sorry.
At page 23 of our bundle.
Yes.
Where Musi AJ, speaking for the unanimous Constitution Court, says the reason for the exclusion of appeals regulated in terms of the CPA or any other criminal procedure from the purview of Chapter 5, that's a reference to the definition of appeal, is to avoid duplication. It would be senseless to have two statutes regulate the same subject matter. The legislature recognized that although the CPA deals comprehensively with appeals in criminal matters, it doesn't do so exhaustively. Chapter 5 of the SC Act, insofar as it deals with appeals, complements and supplements the CPA. The purpose of the definition, therefore, is not only to harmonize the provisions of the two, but also to supplement the provisions of the CPA. Then he goes on to quote the definition of appeal, and he says in 38, the CPA regulates appeals in criminal proceedings in respect of superior courts in 316 to 324 and so on and so forth. Hence our argument that it is in fact regulated, but there is another way of approaching this. Your Lordship may interpret complements and supplements as, because that is the interpretation of the Constitutional Court of this new dispensation, as meaning allows for these generalized intermediate appeals where it is in the interests of justice to do so. And that would be the argument against us, but rooted in the interaction between these two statutes.
But then you carry on and you say it's not in the interest of justice, even if there is such a discretion.
And assuming I've lost that argument, I'd like now
Yes.
to deal with the interests of justice.
Is it convenient, perhaps? I've avoided watching my watch, but I see we've exceeded 1 o'clock. And we need a comfort break for the benefit of those present. Can we resume at 2 o'clock? Or, well, let me give you a bit more. At 15:15.
At any time that suits you, my Lord.
Yes.
I'm a bit concerned about
I want to fit in the, you've had discussions with Mr. Mpofu.
Yes.
How long do you think we will still be? And then allowing some time for a short reply before we're running out of the court day. So before 4.
I will definitely make sure that I'm finished in time to give my learned friend time to reply. He has a very important engagement tomorrow,
yeah.
and it would not be desirable that we have to come back on another day to finish this.
Is that in order, Mr. Mpofu? We'll take the adjournment now.
Yes, my lord. Apropos your question, then maybe we should come back at 2, my lord. On that
At
basis.
2?
Yes, my lord.
And you'll be able to finish before 4?
We will, my lord.
Yes, all right. On that basis, then I'll come back at 2.
Thank you, my lord.
So the court will adjourn for the long adjournment until 2 o'clock.
As a pleasure.
Court will rise. Breitenbach, I don't know whether you've perhaps come across case Director of Public Prosecutions Gauteng versus KM. I don't think it's referred to by the accused either. It's a 3-2 majority in the SCA. And certainly the one paragraph, I've said a brief look, seems to support part of your argument. It says in paragraph 34, that's in the majority judgment, it's 2017-2 SACR 177. The introduction of the definition of an appeal in section 1 of the Superior Courts Act has given rise to a new situation. This must prompt fresh inquiries on matters settled under the previous legislation. Certain appeals are now excluded from the operation of Chapter 5 of the Superior Courts Act. This was not the position under the Supreme Court Act. The inquiry which must be made prior to concluding that Section 16(1)(b), which requires special leave to appeal, applies, is whether the appeal in question is subject to the provisions of Chapter 5. And I'll turn to that inquiry. It's on a 311, and it dealt with the issue of whether leave to appeal was required to be first had and obtained.
Yeah.
But that is what was said. But anyhow, I'll have a look at it in due course.
Thank you, my lord. I'm indebted to you. We're undoubtedly in relatively new and uncharted territory, and assuming your lordship is against me and holds that Chapter 5 of the Superior Courts Act does supplement Chapter 31 of the Criminal Procedure Act by allowing an appeal on an intermediate question before conviction and sentencing, when it is in the interests of justice to do so, I now turn to the question of what the interests of justice require in this case. In our submission, for 5 reasons, an appeal at this stage would be contrary to the interests of justice. In other words, the interests of justice in fact require that the matter now proceed to trial on the accused's pleas of not guilty. The first concerns Mr. Zuma's characterization of his special plea, and indeed of the many grounds on which it is based. He relies primarily on prosecutorial misconduct. And he says in paragraph 11 of his application for leave to appeal, that raises the question whether he will receive a fair trial. However, as this court pointed out in paragraph 77 of its judgment and elsewhere, that is an issue best determined when the evidence in the criminal trial has been heard, digested in the light of the conflicting evidence, and the credibility to be attached to the evidence has been properly assessed. Other paragraphs dealing with this issue are paragraphs 108 and 135 sub F of the judgment, which are quoted in our heads of argument at page 19 in paragraphs 48.2 and 48.3. I refer only to the first of those, where this court held as follows: whether an accused will ultimately receive a fair trial is a question to be answered on all the evidence. It's probably most appropriately decided, although this is solely in the discretion of the trial court, at the end of the trial, if the alleged lack of objectivity or independence, whether due to alleged political interference or influence by outside intelligence agencies or any other cause, is such that an accused will not receive a constitutionally fair trial, then a variety of remedies may be available in the discretion of the court in terms of section 172(1)(b) of the Constitution, as the circumstances may demand. And we would emphasize this fundamental point. Mr. Zuma's case, insofar as his not getting a fair trial is concerned because of the involvement of Mr. Downer, in other words, Mr. Downer's involvement will imperil his right to a fair trial, is essentially speculative. The proof of the pudding will be in the trial itself. Evidence will be led, and once that is done, this court will be in a position to assess that contention, the merit of that contention. So we respectfully agree that it's in the interests of justice that any question about whether Mr. Zuma has received a fair trial is best determined by this court at the end of the trial, or in its discretion, should something happen in the course of the trial which requires, in this court's estimation, that the matter be determined sooner than that, earlier in the trial. And that, with respect, is the fundamental problem which my learned friends face in this case. They predict something will happen, but as this court, with respect, correctly pointed out, whether or not there will be an adverse impact on the fairness of the trial is something which will become apparent during the course of the trial. So the interests of justice point to that question being determined not hypothetically or in the abstract, but with reference to what actually happens in the case. And secondly, as the court mentioned in argument earlier and was pointed out in the Western Areas case at paragraph 25 in our bundle at page 34, and I quote, "Long experience has taught that in general it's in the interests of justice that an appeal await the completion of a case, whether civil or criminal. Resort to a higher court during proceedings can result in delay, fragmentation of the process, determination of issues based on an inadequate record," and here's the portion which we would particularly emphasize in the light of the nature of the complaint raised, "and the expenditure of time and effort on issues which may not have arisen had the process be left to run its ordinary course." For this reason, as was pointed out in Ismail's case at 5H to 6A, that's in our bundle at page 47, that's Ismail and others versus the additional magistrate Weinberg and another, quoting the earlier Valhouse decision. The general rule applies, and what could turn out to be a piecemeal appeal should be permitted as an exception to that rule only in those, and I quote, "rare cases where grave injustice might otherwise result, or injustice might by other means not be attained." In the present matter, however, an appeal against the dismissal of the special plea, if Mr. Zuma is convicted, and only if he is convicted, and is then granted leave to appeal, is a means by which justice can be attained. And the reason is because when the evidence has been led, the impact, if any, of Mr. Downer's involvement in the fairness of Mr. Downer's involvement on the fairness of the trial can be assessed. Our third reason for contending that an intermediate appeal at this stage would not be in the interests of the justice is the following. It is clear, we submit, that it would not be in the interests of justice to permit such an appeal if the applicant for leave to appeal has poor prospects of success in the intended appeal. The reason for that is that the likelihood is that the appeal will be a waste of time. It will cause yet further delay, something to which I shall return in a moment. As I shall outline in a moment, in our submission, Mr. Zuma's intended appeal against the dismissal of his special plea does indeed have poor prospects of success. The fourth reason is that the criminal trial in respect of the present accused has already been delayed unreasonable. Further delay will prejudice the interests of the general public, we submit, represented by the state, in having the prosecution and defence cases fully ventilated as soon as practically possible. And it will also affect the right of the second accused, conferred by section 35(3) of the Constitution, to have the trial in respect of its plea of not guilty begin and conclude without further unreasonable delay. The fifth and final reason
Sorry,
on which
just
we
where are you in
rely.
your heads of argument now, Mr.
My Lord,
Right.
I'm in the section at pages 17 to 22, paragraphs 43 to 58.
Yes. I see, yes. You're now on the fourth one, eh?
I'm at the fourth reason, and I'm now moving on to the fifth
Fifth.
one, which is on page 22 in paragraph 56. The fifth, and this is our final reason why in our submission and appeal at this stage would be contrary to the interests of justice, is the following. With respect, Mr. Zuma's special plea is the latest in a long line of preliminary cases brought by both of the accused, which have had the effect of obstructing and delaying the start of the criminal trial on the merits of the charges against them. And in this regard, we refer to the court to the case of National Director of Public Prosecutions versus King, 2010, Volume 2, SACR 146 SCA, paragraph 5. It's in our bundle at page 51, where from halfway down that paragraph, the SCA said, amongst other things, the following, and I quote, "The fair trial right does not mean a predilection for technical niceties and ingenious legal stratagems, or to encourage preliminary litigation, a pervasive feature of white-collar crime cases in this country. To the contrary, courts should, within the confines of fairness, actively discourage preliminary litigation. Courts should further be aware that persons facing serious charges, and especially minimum sentences, have little inclination to cooperate in a process that may lead to their conviction. And any new procedure can offer opportunities capable of exploitation to obstruct and delay. One can add the tendency of such accused, instead of confronting the charge, of attacking the prosecution." With respect, King obliges our courts, and this court in this matter, to discourage actively preliminary litigation like the present. Obviously, they must do so only if fairness can be achieved in the criminal trial itself. But that is something which this court has made abundantly clear in its judgment can be done if any credible grounds for a finding that Mr. Zuma has not had a fair trial remain after the evidence on both sides has been led. That concludes our submissions on the question of the interests of justice. I turn to a brief discussion of prospects of success. We deal with this issue in our heads at pages 23 to 29, paragraphs 59 to 70. The four building blocks of our argument are the following. First, with respect, this court was clearly right in holding, in paragraph 69 of the judgment, that the issue for determination raised by the special plea was Mr. Zuma's allegation that Mr. Downer lacks title to prosecute, as provided in section 1061H of the CPA, and nothing more. Section 1061H entitles an accused to plead, and I quote, that the prosecutor has no title to prosecute. The first sentence of Mr. Zuma's special plea reads as follows: "I give notice of my intention to raise a further plea in terms of section 1061H of the Criminal Procedure Act 51 of 1977, that, for the reasons that are set out in the plea explanation, Mr. Downer SC should be removed as the prosecutor in this case, as he has no title to prosecute." That was the plea, and that was the sole question for decision. In our respectful submission, the fact that Mr. Zuma wrongly invoked alleged infringements of his right to a fair trial in Section 35(3) of the Constitution in support of his special plea does not detract from the fact that that was the sole question for determination by this court. Indeed, it could not have been otherwise because of the wording of Section 1061H of the Criminal Procedure Act. The only question for decision seriously raised in relation to the special plea, and properly raised, was the meaning of the word title or phrase title to prosecute, or the word title in Section 1061H. And that brings us to our second point as to his poor prospects of success. This court said, with respect correctly, that its primary finding in the case, which led to the dismissal of the special plea, was that the word title in that section should be assigned the narrow meaning of a prosecutor's standing or authority to prosecute, rather than the wider meaning for which Mr. Zuma contended, as including where the retention of a person as the prosecutor will infringe the accused's fair trial rights entrenched in Section 35(3) of the Constitution. As Mr. Zuma did not dispute Mr. Downer's standing or authority to prosecute, this court's primary finding meant the end of the special plea. We refer in this regard to Mr. Downer's main answering affidavit at paragraphs 5 and 8, which are in the main record at pages 1455 and 1456, which were not disputed in reply. And here we refer the court to page 4184, paragraphs 54 and 55. Those were the allegations that Mr. Downer had been duly designated to conduct this prosecution by the former and current Director of Public Prosecutions for this division. We also refer in this regard respectfully to paragraphs 130 and 131 of the court's judgment. Our third reason for submitting that Mr. Zuma's prospects of success in the intended appeal are poor is the following. He can succeed in the SCA only if he persuades it that Porritt was clearly wrong. Before dealing with that, I should say something briefly about my learned friend's reference to paragraph 17 of Porritt, where it said that an accused who contends that he won't receive a fair trial at the hands of a particular prosecutor is not remediless. As this court pointed out in its judgment, the remedy is a different one from that provided to an accused by Section 1061H of the Criminal Procedure Act. An application directly based on Section 35(3) of the Constitution would be one of the remedies available. There may be others, including a request for an acquittal based on a failure or an irremediable infringement of the right to a fair trial. But there is no question of any ambiguity on this issue in Porritt. In other words, on the scope, limited scope of 1061H. As this court pointed out in paragraph 109D of its judgment, Porritt, particularly paragraph 8, which we submit must be read with paragraph 7, could not be clearer. So Mr. Zuma can succeed in the SCA only if he persuades it that Porritt was clearly wrong. I paused to point out, at the risk of stating the obvious, that where the SCA has already decided a legal point like this in a way adversely to an intended appellant, the appellant or intended appellant has a very formidable obstacle in the way of his or her prospects of success. I would submit, with respect, that save in the most exceptional cases, they cannot be regarded as reasonable, because the SCA has considered the question and determined it against the proposition sought to be advanced in the intended appeal. Moreover, with respect, as appears from this court's analysis in paragraphs 82 to 96 of the judgment of both the ordinary meaning of the word title in section 1061A, as well as of the CPA context in which it occurs, the narrow meaning adopted by the SCA in Porritt, far from being arguably clearly wrong, is undoubtedly clearly right.
But it's not my call too.
Indeed, my lord. But that is what has...
If it's in point, then I don't have a discretion.
I would hesitate to embrace that proposition. The applicant before you is seeking to engage the jurisdiction of a higher court, which will have the power, in the limited circumstances permitted by Camps Bay, to reverse its decision if it's clearly wrong. And so I would submit...
But isn't it for that court to say it wishes to reconsider it by way of a petition?
It may be hypothetical, but I can imagine circumstances in which a judge has considered a submission which is hit by binding higher authority, has carefully considered that authority, and unlike your lordship, who has wholeheartedly agreed with the authority, has said, I'm bound by it and I apply it. But for the following reasons, I believe that case was wrongly decided. And in those circumstances, the court, if it believes that it was clearly wrongly decided, or at least arguably so, which one would imagine would be the case in the circumstances I've just postulated, could send the matter on appeal. But in this case, your lordship has agreed without reservation with what the Supreme Court of Appeal said the word title in 1061H means. So, my lord, I'd be hesitant to say that you don't deal with the question at all by simply doing what one does in the main case by saying, well, I'm bound by that. The fourth reason why we submit Mr. Zuma's prospects of success in the intended appeal of poor has to do with the intended attack on the court's decision in the exercise of the discretion conferred on it by Section 108 of the Criminal Procedure Act and Section 173 of the Constitution, both referred to in the judgment, namely its decision for the reasons given in paragraphs 46 to 60 of the judgment that Mr. Zuma's special plea should be tried by the exchange of affidavits, as had been agreed by Mr. Zuma and the state, and consequently ordered by this court when the special plea was entered on the 26th of May, 2021. And we would emphasize only 2 points in this regard. The first is it was Mr. Zuma who initiated the process when he substantiated his special plea by means of a plea explanation in the form of a founding affidavit. And secondly, as I explained before the luncheon adjournment and elaborated on just now when dealing with his prospects on the merits of the primary question, his special plea was excipiable on its face, because on the binding authority of Porritt, the complaints underpinning it did not relate to Mr. Dana's title to prosecute. And the point is that no amount of viva voce evidence could have resolved this fundamental problem with his special plea. In fact, it would have been contrary to the inimical to the interests of justice to allow a trial in relation to allegations which could not sustain a special plea under section 1061H. That then brings me to the application for leave to adduce further evidence. Mr. Zuma has applied under section 316(5) of the Criminal Procedure Act for leave to adduce further evidence in his intended appeal, namely his affidavit dated 21 October 21 in support of the criminal complaint against Mr. Downer, which he lodged with the South African Police Service in Pietermaritzburg on that day. We have dealt with this application in our heads at pages 29 to 35, paragraphs 71 to 92, and we submit that for 8 reasons this application falls to be dismissed. The first is that such an application, 316(5), may be made only if and when an accused is making an application under section 316(1). That much is clear from the introductory words of section 316(5). An application for leave to appeal under subsection 1 may be accompanied by an application to adduce further evidence, and so on. Now, my Lord, as we see the matter, there are only 2 avenues open to Mr. Zuma at this stage to get to the Supreme Court of Appeal. The one is under section 319, not section 316 sub 1. The other is on an interpretation of Chapter 5 of the Superior Courts Act as being complementary to the appeal provisions in Chapter 31 of the Criminal Procedure Act in those cases where an appeal on an intermediate ruling judgment would be in the interests of justice. In both of those cases, section 316 is not engaged, and if any evidence is to be led, additional evidence is to be admitted in the appeal, then that is a matter for the Supreme Court of Appeal to decide, probably under section 19 sub B of the Superior Courts Act, which allows an appellate court, in addition to any power that may be specifically provided for in any other law, to receive further evidence. So we submit that for this reason alone, we're not dealing with the section 3161 appeal, that the application under 3165 falls to be dismissed. The second reason is that none of the evidence in Mr. Zuma's affidavit of the 21st of October last year relates to the issue of whether or not Mr. Downer lacks title to prosecute the accused in this matter. In other words, title as interpreted by the SCA in Porritt and applied in this court's judgment. The third is that much of the supposed new evidence doesn't concern Mr. Downer at all, and we refer in this regard to the evidence described in our heads at page 32 in paragraphs 83.1 and 83.2. That's the evidence concerning Mr. McCarthy, Mr. Nguka, and also Mr. Piccoli in the context of Browse Mill. Your Lordship heard lengthy submissions, or relatively lengthy submissions, about Mr. McCarthy and Mr. Nguka this morning. But that doesn't concern Mr. Downer at all. The fourth point, which relates to section 316(5)(b) sub 1. If my learned friend had careful regard to our heads, he would have seen that we not only had read but also quoted that section. It understandably applies to, and I quote, further evidence which would presumably be accepted as true. The problem is that much of the supposed further evidence isn't further evidence, because it's a repetition of matter raised in Mr. Zuma's affidavits in this court in support of the special plea. And that applies to all of the evidence described in paragraph 83 of our heads on pages 32 and 33. The fifth problem is that the supposed further evidence is not evidence which would presumably be accepted as true. And that's not just because Mr. Downer denied it in his answering papers in the special plea, denied the allegations, but more importantly, in its judgment, in the alternative to its primary finding, this court surveyed these and the other allegations comprising Mr. Zuma's 14 grounds of complaint or attack, and concluded that all of them were unfounded. The sixth problem relates to section 315b2, the second of the requirements, which is that the further evidence must be such that if accepted, it could reasonably lead to a different verdict or sentence. Those are the important words, verdict or sentence. Our submission is that even if they were accepted, none of the three allegations in Mr. Zuma's affidavit of the 21st of October, which do concern Mr. Downer, would justify a finding in his favour on the special plea, let alone his acquittal in terms of section 1064. Those three allegations are the ones referred to in our heads on page 33, paragraphs 83.3 and 83.4, as well as the further allegation in paragraph 15 of Mr. Zuma's affidavit that the prosecution team authorised Professor Sarkin to send his life partner to handle sensitive medical information without the necessary authorisation. Our submission is that at best for Mr. Zuma, if those allegations were accepted, which we submit they shouldn't be, they would constitute irregularities not affecting the merits of the prosecution or the fairness of the trial. Seventh, there is the fact that we submit that the mere fact that Mr. Zuma has laid a criminal charge against Mr. Downer isn't in and of itself a fact which could reasonably lead to a different outcome in relation to the special plea or to a different verdict or sentence. The reason is the fact of the laying of the criminal charge is irrelevant to both of those matters. The eighth and final reason why the application for leave to adduce further evidence should be refused is the following. It concerns section 316(5)(b)(3), which requires, and I quote, a reasonably acceptable explanation for the failure to produce the evidence before the close of the trial. Now, the proceedings in relation to the special plea closed in our submission when this court delivered its judgment on the plea on the 26th of October 2021. And that, we emphasize, is the date that it had indicated that it would endeavour to meet the target date when it reserved judgment following the oral argument on the 22nd of September 2021. We know that Mr. Zuma laid the criminal charge on the 21st of October, and he hasn't explained why he did not apply to this court for leave to adduce the further evidence when he was in Pietermaritzburg on that day, or for that matter, on any of the 22nd, 23rd, 24th or 25th of October. That then brings me to the application for a special entry. There's quite a bit of confusion about this on the papers with respect. In paragraphs 22 to 30 of his replying affidavit in the application for leave to appeal, that's the one which isn't actually a replying affidavit, but motivates these alternatives, or explains why, it takes these two preliminary points and then goes on to motivate two applications. The first is an application in terms of section 319(1) of the Criminal Procedure Act for the reservation of several questions of law for the consideration of the SCA. I'll deal lastly with that in a moment. And secondly, and in the alternative, he applies in terms of section 317(1) of the Criminal Procedure Act for the making on the record of a special entry of an irregularity or illegality. Now, we deal with this aspect. This is now the section 317(1) application. in our heads at pages 35 to 37, paragraphs 93 to 98. And we point out that Mr. Zuma's counsel's heads do not refer to section 317 at all. Perhaps that is because there's no warrant for the making of a special entry, and we emphasize three of the reasons for that submission as follows. The first is that the purpose of a special entry is to raise an irregularity in connection with or during the trial as a ground of appeal against a conviction under section 318(1). The two provisions have to be read together, 317 and 318. 381 provides, amongst other things, that if a special entry is made on the record, the person convicted may appeal to the SCA against their conviction on the basis of the irregularity stated in the special entry. And this is made clear, the fact that this is the purpose, in the case of Nkabinda, State and Nkabinda, and others, 2017, Volume 2, SACR 431, SCA, paragraph 27, and it's in our bundle at pages 101 to 102. Mr. Zuma has not yet been convicted, and he may never be. Secondly, neither Mr. Zuma's objection to what the parties misunderstood to be this court's direction that the state deliver an affidavit in answer to his application for leave to appeal, nor his objection to Mr. Downer's making of that affidavit on behalf of the state is relevant to the merits of the criminal charges against him. In other words, to the issue of whether he should be convicted or acquitted on those charges. The third reason is that insofar as Mr. Zuma may be relying for the special entry on his grounds of appeal against this court's dismissal of his special plea in terms of 1061H, the record contains everything which may be relevant. We point out that he asserts as much in his replying affidavit at paragraph 28, when he says, and I quote, "The factual bases for the special plea are largely common cause. The main application was primarily based on a set of admitted facts extracted from the answering affidavit." That was how the argument was presented on 21 and 22 September at any rate. In our submission, following S.V. Staggie, S-T-A-G-G-I-E, 2012, Volume 2, SACR 311 SCA, paragraph 16, in our bundle at pages 97 to 98, the section 317 procedure cannot be followed where the alleged irregularity or illegality appears from the record. Lastly then, the application for the reservation of questions of law. As I mentioned a short while ago, Mr. Zuma applies for the reservation of several questions of law for the consideration of the SCA in terms of section 319. We deal with this application in our heads at pages 38 to 40, paragraphs 99 to 104, but in the light of my learned friend's reliance on S.V. Basson, 2007, Volume 3, SA 582, CC, at paragraph 152, our submissions have undergone some adaptation. And I'll draw the court's attention to the relevant adaptation. We submit that there are 5 main difficulties with this application. The first is that in the relevant part of his affidavit, which is paragraphs 22 to 30 of his replying affidavit, he does not identify the questions of law. If one has regard to his counsel's heads, and specifically paragraph 11, it appears that the issue sought to be raised in this way may be confined to his contention that this court could not validly direct that answering and replying papers be filed in an application for leave to appeal. Now, if that is so, then we submit in the light of this court's elucidation that its direction was confined to the 316.5 application for leave to adduce further evidence. The foundation for the supposed question of law has fallen away. But elsewhere in his affidavit, this is his replying affidavit, and specifically paragraph 24, he describes the Section 319 application as if it relates to, and I quote, the entire special plea proceedings. If that is so, then we submit the application loses sight of the fact that 319 is designed to deal with the reservation of questions of law, not questions of fact. And we submit that the question whether the evidence establishes facts which supports Mr. Zuma's 14 grounds of complaint is a question of fact and not a question of law. And that submission applies in practical terms to the whole of the alternative basis of this court's judgment relating to the merits of the 14 grounds of complaint advanced on Mr. Zuma's behalf in September last year when the matter was heard. The third problem with this application is if it's confined to this court's interpretation of the word title in section 106(1)(h), which we accept is obviously a question of law, and hence it is appealable under section 319 at any stage in these proceedings. In other words, on the authority of Basson, para 152, also before conviction and sentencing. We refer to what we said earlier about Mr. Zuma's poor prospects of persuading the SCA that Porritt was clearly wrong and that his wider interpretation of title in 106(1)(h) should be accepted. And the reason we do that is that following the judgment in an earlier Basson case in the SCA, that's Basson, Essen Basson 2003 2 SACR 373 SCA at paragraph 10, which is at page 117 in our bundle. And the English translation of that may be found in a later SCA case applying the same principle. It's SV, I'll spell the surname, POOE, 2021, volume 2 SACR 115 SCA, paragraph 38, which is at page 122 of our bundle. The court will not exercise the discretion to reserve a question of law for the consideration of the SCA if there is no reasonable prospect of a finding by the SCA that a mistake of law was made. Fourthly, we submit that there is a further reason why the court should not exercise its discretion in favour of reserving a question of this particular question of law, or any other for that matter, for the consideration of the SCA in this matter. And that is that where such a reservation is sought in the course of a criminal trial which has not yet resulted in the conviction and sentencing of the accused, then the question of law should only be reserved at the intermediate stage if the interests of justice so require. But for the reasons given earlier, in our submission, the interests of justice require the contrary, namely that the matter now proceed to trial on the accused's pleas of not guilty. The fifth reason why we submit this application should be refused is that in our submission, the purpose of section 319 must be to permit the SCA to consider and to provide the answer to a question of law which it has not previously decided. In other words, if a High Court is to grapple with a new question of law, new in the sense that the SCA has not decided it, and the answer to that question will or may have a decisive bearing on the shape and further conduct of a criminal trial, then a court may legitimately, under this provision, refer that question for the consideration of the Supreme Court of Appeal, with the necessary consequence that the trial would be held in abeyance in the meantime. All of that doesn't apply where, as has happened here, the SCA has already decided the question of law. It has already decided the proper interpretation of Section 1061H. For all of these reasons, then, the State asks that all of the applications by the first accused be dismissed.
Yes, thank you. Reply, Mr. Mpofu.
Thank you, my Lord. Lord, I wish to start by trying, hopefully for the last time, to indicate that this porridge bogeyman is non-existent. I tried in the previous case, and I tried also this morning. But let me qualify it like this, my Lord, up front. It's not my task to convince your Lordship that your Lordship's interpretation of porridge is wrong or right or whatever, or that ours is right or wrong, because this is an application for leave to appeal. It's not an exercise in madness, as Albert Einstein once said, that trying to do the same thing and expecting different results is a sign of madness. So we are not here to re-argue the point. But I am hoping, my Lord, if you hear nothing else in this reply, it is that you will hear that the case of porridge is, we are not here to say that porridge was incorrectly decided. On the contrary, we say porridge was correctly decided. But we say that correct decision in porridge has got absolutely nothing to do with the business that we have here. That case is distinguishable on so many grounds that sorry, I've got it. So your Lordship need not worry about this idea that if you grant leave to appeal, then the SCA would say, if the case was applicable, and the Lordship is quite correct in that, SCA would say, but yeah, we've explained this thing, and there's a single judge, he has no choice in the matter, even if he might think that we are wrong, he's bound. We get that. But that's not what we're saying, my Lord, with the greatest respect. What we're saying is that Porrit was, firstly, let's go to paragraph 6 of Porrit. And I want to do this slowly, even at the expense of my other points. My learned friend says Porrit answered the question. What was the question? And does that question, is it raised here? Sorry,
Sorry, I've just overlooked Ms. Jackson earlier before your reply. Ms. Jackson, you're here for...
Oh yes, of course, my lord. Yes.
The next thing you're going to say, there's an irregularity, Mr.
Never irregularity.
My sincere apologies. I understood that you were here more from an observer status point of view. You're not here to make submissions, either way or in any way. So the fact that I've overlooked you is not a problem.
It's not a problem.
Very well, thank you. Sorry, Mr. Mpofu.
Okay, my lord. We won't enter.
There's so many advocates sitting there, it slipped my
That's
mind.
correct, my lord. I can assure you, lordship, we won't enter another point of law. Yes, my lord, yes, I was...
Sorry to have interrupted you. You've now
No.
interrupted your train of thought.
Not at all, not at all.
You were dealing with Porrit?
Yes.
And paragraph 6.
And
you
the
wanted to
paragraph
start.
6, that's correct.
Yes.
And I was saying, my lord, the question, Porrit was first and foremost a Section 319 application. So on that score alone, it is distinguishable from what we are busy with here. But of course, I understand that. Let's assume in the Section 319, the question that was asked was the same question that we're asking of you, my lord. Then it would, whether it was a 319 or whatever, wouldn't matter. So let's look at the question. Bear in mind, it says 6A. Here's the question that was posed to the SCA. What is the legal test to be applied either in terms of Section 1061H of the Criminal Procedure Act or the common law for the removal of a prosecutor? That's the question that was asked in Porrit. What on earth has that got to do with the interpretation of title, the phrase title to prosecute? And your lordship's judgment has said somewhere that this application that we brought here was not about the removal of a prosecutor. We argued that point unsuccessfully in the main application. So now, opportunistically, we would say, let's assume that your lordship is correct, that there's some difference between such a removal application and what we are busy with here. Well, then the state can't have it both ways. Mr. Strengov stood here and said that ours is not an application for a removal. They can now, on appeal, when it suits them, say, no, it actually is an application for a removal. So, my lord, Porrit, on their own interpretation of the law, deals with something else called a removal of a prosecutor. We are not busy with that here. We are busy with a completely different thing. And I'm ready to concede that both questions deal with the legal test and the interpretation. But it's a different thrust that we are bringing here, my lord. Namely, and it's quite a simple one, in the interpretation of the phrase title to prosecute, should a court of law adopt a narrow interpretation which confines that question to issues of the authority and the certificate and the authorization by the NDPP and so on? Or should the court adopt a wider interpretation which is in line with Section 39(2) of the Constitution. Section 39(2) of the Constitution, and if I may add, Porritt did no such thing of a Section 39(2) interpretation. And Section 39(2) simply says, when interpreting any legislation, in this case 1061H, and when developing the common law, which is irrelevant to this, it was relevant in Porritt but not here, or customary law, every court must promote the spirit, purport, and objects of the Bill of Rights. That is all, my lord. That really is the only question before you, not the question that was posed in Porritt. And that question has not been answered, let alone by the SCA, but not by any court. So firstly, the SCA is not doesn't have to deal with some problem about, or do we have to overrule, because they've never dealt with this question. And again, going back to Albert Einstein, it is not our job to say to your lordship, no, the wider interpretation is correct. That would be a waste of our time and yours, my lord. All we have to establish now is whether there is a reasonable possibility that another court, a higher court, might will find, on the new test, will find that the wider interpretation, which follows Section 39(2) of the Constitution, is the correct one. That's all. Is there or is there not a reasonable possibility that a higher court will find, unlike this court, that the correct interpretation of Section 1061H of the Criminal Procedure Act, particularly with reference to the phrase title to prosecute, should be interpreted on the Section 39(2) test? Yes or no? If there is such a reasonable possibility, leave to appeal must be granted. If there is not such a possibility, then the court must go on to determine whether there are other compelling reasons why leave to appeal should nevertheless be granted. That is the end of our business here today. Porritt goes further at paragraph 7 and makes a point. My learned friend says we must look at paragraph 7. I will demonstrate that paragraph 7 of Porritt also has absolutely nothing with this case. Porritt paragraph 7 is summarizing the last words of that paragraph, which says that the NDPP, on the other hand, contended that once a plea challenging the title of a prosecutor was dismissed and no plea, such as a plea of not guilty, had been tendered, the appellants cannot rely on Section 1064 to demand an acquittal. We agree. But that case is not this case. This is not a case where a plea of not guilty has been entered. On the 26th of May 2021, I stood here and entered a plea of not guilty to this court. So, with the greatest respect, let's scratch off paragraph 6, let's scratch off paragraph 7. Let's go to the last one. and read it together slowly. Paragraph 8. And that's the one where, as I say, I'm hoping one day I'll be able to explain. Paragraph 8 says that in that case of Porret, my counterpart, the appellant, had brought that matter on a 1061H, that question that we say is irrelevant to this case, on the basis of 1061H, and the Porret said it was not necessary for the appellant to place reliance on section 1061H for their application for the removal of the prosecutor on the basis that they were biased. That application. But it goes further and says that the appellants, indeed the counsel for the appellants advised from the bar that the application for the removal of the prosecutor on the ground of an apprehension of bias was separate from the 1061H plea. How can it be clearer than that? The counsel, whatever his name was, said that in his case, not mine, there was a separate application for the removal and another one for under 1061H. What has that got to do with this case? And then it says, but the two issues were argued together by agreement between the two sets of counsel. And then I conclude that the removal of the prosecutor was not grounded, the removal by the court was not grounded on a lack of title in terms of 1061H of the Criminal Procedure Act. And the appellants were therefore not entitled to demand an acquittal from section 1064. That is all that Porret is about. But for the avoidance of doubt, maybe before I get there, this is another distinguishing point. That case of Porret was therefore solely based on the alleged apprehension of bias. This case of President Zuma is not solely based on bias. It is based on misconduct. It is based, yes, on bias. It is based now on alleged criminal conduct. And it is based on the breach of the prosecutorial code, which we referred to. There was some case, I forgot, it was an Afrikaans case that we referred to in the previous case, for Mark or something. I'll try and find it, my lord, which outlined, your lordship will remember, outlined the codes, the prosecutorial code, and I went through it and I said this was breached, this was breached, this was breached, this was breached in September last year. So even if, let's say for argument's sake, I explained this in the morning, that the only coincidence between the Porret complaint and this case would be the DA affidavit. Because in the Porret case, the prosecutor Ferreira was accused of having deposed to an affidavit in a separate civil matter, and therefore he was biased. So let's say for argument's sake that is a point of coincidence. What about all the other grounds of that I've enumerated? So Porret, with the greatest respect, is just a red herring that is just being waved here to obfuscate the issues. Okay, I'm sorry, my lord. I've mixed up my Afrikaans surnames. It was S. van der Weesthuizen, not Vermaak. 2011-2 SACR 26, a decision of the Supreme Court of Appeal. And at paragraph 6 of that it talked about the impartiality of a prosecutor, and then it went on, 179.4, and then it had the following headings, the part that I read out in the court earlier, at paragraph 6, independence, impartiality, and then the role in criminal proceedings. And then it talks about avoiding participation in political or other activities, remain unaffected by sectional interests and public media pressure, and so on and so on. But I'm not re-arguing that point. I'm simply saying, even if, let's say, the question we were asking you to answer, the court, I'm sorry, my lord, to answer in this case was, let's say it was only the DA matter. Then someone could have then said, okay, well, the two cases, the questions might not be exactly the same, but at least they deal with the same thing. But here we deal with far much more than that. And where I was going is paragraph 17, where Porrit is just being misquoted and misrepresented. The court, having made even those submissions, said, but this does not mean that a prosecutor can never be disqualified on the grounds of bias or apprehension of bias, where his or her bias affects the accused's right to a fair trial, which we all now have agreed is this case here. A prosecutor may well be disqualified. In other words, 106(1)H would apply. In Smythe versus Usheokunze and another, Mr. Smythe ran several youth camps in Zimbabwe. He was charged with culpable homicide, and Lordship knows the facts. It turned out that one of the teachers was a friend of the accused, and so on, and the prosecutor was removed on that basis. So, on anybody who reads Porrit would understand that Porrit is really not a bar to this application. Then, my lord, Mr. And here I must take some of the blame. Maybe it was the articulation in the heads of argument. Mr. Breitenbach seemed to suggest, my lord, that the question of law reserved was merely confined to the new question about the procedure. Well, my lord, that is not the case, and if we gave that impression, then we apologize. We have set out very clearly in the I think it's page 71, my lord.
You're referring to your heads?
No, our reply.
Oh, your reply.
Yes. Yes, no, 79, sorry, ma'am.
Page 79.
79 of our bundle.
Yes.
We make it clear there that the points of law that are being raised are effectively they mimic the points of law that we had raised as the grounds of appeal based on law.
So which paragraph are you referring to?
23, my lord.
23.
Yes.
Thank you.
This is what President Zuma says this in that paragraph. He says, this I do by placing reliance on some of the purely legal grounds of appeal contained in the notice of application for leave to appeal, which must be read as if specifically incorporated herein, as well as spelling out the factual, sorry, it should be factual. Factional, I think President Zuma was thinking of something else at that time. the factual basis underlying these questions of law as spelled out below. And then we say, in any event, the entire special plea proceedings are by definition based on a point of law. And by that, a special plea or exception raises a point of law. I don't have to motivate that to His Lordship. But what we meant there is that insofar as it's called a special plea and a preliminary point, by definition, it's a point of law. Then said, I'm advised that in respect of section 1061H proceeding, there's a precedence for this approach as exemplified in Porrit and supported by other binding authorities which will be relied upon during legal argument. Academic authorities also sufficiently support this approach. In other words, what we're saying there is that Porrit itself is an example that you can take a question of law to the Supreme Court, and that was done, and it was accepted, and it was dealt with. So that's what we're doing as well, when we're entitled to do it, just like the litigants in Porrit were. And then we say there are no specific timelines within which such an application may be brought. That's a common cause. And here's where I think the mistake came, my lord, if it's on our part. We then say additional issues which justify a referral to the SCA in terms of section 319 or 317 of the CPA are the irregularities identified in the two objections raised above about the irregular procedure and or the inappropriate deponent. We have obviously not pursued the inappropriate deponent issue as such an additional question of law, but we do when it comes to the procedural point. That's all. So maybe, and I that's why I said Mr. Breitenbach maybe was had a point. Maybe what we should have then said in our heads is the additional ground that we referred to here. The question will be this, but by no stretch of the imagination did we abandon the points of law that are in the previous. So in other words, my lord, your lordship and Mr. Breitenbach, my learned friend, is quite correct. The lordship is quite indeed free to frame some of the questions and to frame them along the lines that we have raised in our application for leave to appeal, or that we raise them in the application itself. But I've already framed the question. The one everlasting question is whether there is the wider interpretation that should be pursued or the narrower one. And then the SCA can decide. Maybe the SCA will agree with your lordship that the narrower one is preferable. Maybe it won't. I don't know. But it's not bound by anything in that respect, because it has never considered that question. And yes. So that's the 319 ground, which on its own would entitle us for leave to appeal on the broad basis set out in the affidavit. In fairness to my learned friend, Mr. Breitenbach, he did postulate both possibilities. He said, well, there's the narrow version in the heads, but he was also going to address the broader version that we had contended earlier. And I just want to make it clear that we pose the new question, so to speak, under the rubric of additional grounds. Then, my lord, if I may be allowed, there was a reference to the case of King. My version. Is that mine? No. Oh, sorry, my. Okay. Oh yes, I must apologize to my learned junior. I was accusing a false left giving me the wrong document. That case, my lord, Mr. Breitenbach read from paragraph 5 of the case of King. That would be National Director of Public Prosecutions versus King, 2010-2 SACR 146, decision of the Supreme Court of Appeal. I just wanted to refer your lordship to, I already referred your lordship to paragraph 41. I have a feeling that I might have cited the wrong case when I said 41 and 52. 52 being the judgment of Nugent J.A. But if I did, then it is this case of King. At paragraph 41, the citing S versus Western Areas, the court held that, or rather relied on S versus Western Areas for the proposition that a judicial pronouncement that is not a judgment or order, such as an interim ruling during a criminal trial, which is what we are about, may be appealable if the interests of justice require it.
That's when the questioner asked that even if it doesn't satisfy Zweni,
Absolutely.
the overriding consideration is then interest of justice.
Yes. And your lordship, actually, there's the case that your lordship gave us this morning. I can't remember the citation, but I've got the page reference. That question and this portion.
This is KM, the one that I referred to.
Yes.
Okay.
KM. Yes. NDPP
versus KM.
Thank you, my lord. I went that to your lordship. Now, the approach taken in that case, my lord, from the little bit that your lordship summarized, is on all fours with this approach in King of the SCA. Let me summarize it as follows, because your lordship has preempted what I was going to say, to suggest that I can do it in shorthand. Section 21 of the Superior Courts Act 10 of 2013 has since been, or rather, of the Supreme Court Act, has since been replaced, as we know, by Section 16 of the Superior Courts Act number 10 of 2013, particularly in respect of this aspect. And the lordship will find that juxtaposition of the two in Erasmus under the discussion on section 16 and I'm hoping on this one your lordship has got the updated version. This is the 2020 version. It's at A2, my lord, -42. The lordship will see there that they discuss section 21(1) of the now repealed Supreme Court Act 59 of 1959. And then they say now the position under section 16 on the next page, or under section 16 of the current act. And I won't bore your lordship with the discussion there, but predictably the first two sentences talks about Zweni, which is what your lordship has just postulated. So, but the shorthand is this. The word decision, which your lordship referred to in the morning, has survived that legislative amendment, because even under section 16, it still talks about the decision. So that answers the question that your lordship posed to me sometime in the morning when we were talking about S versus Basson. So the legislative evolution of that section has not affected that point about the word decision. And therefore, whichever way you look at it, whether you want to look at it from Section 16, the powers in Section 16 of the Superior Courts Act, or the interpretational, probably more difficult route of trying to interpret the word conviction and so on. The bottom line is this, that the appealability as an interim ruling ruling given during a criminal trial may be appealable if the interests of justice so determine. That's the bottom line. And
Were you quoting there from paragraph 41 of King's case?
that's 41, Malone.
Thank you.
And then 52 is to the same effect. I think I referred to it in the morning. Then, my lord, I just want to again to re-emphasize the conditionality of the 317 and 319 point, but I think that point was made in the morning.
Conditionality is dependent on leave to appeal being refused.
Yes, that's correct.
That's what you said this morning.
That's correct, my lord, yes. I accept that if your lordship...
If leave to appeal is refused, does the application in 3165 fall away?
Yes, the 3165 falls away, but then the 317 and 319 kicks in conditionally upon that. That's correct.
What you submitted this morning.
That's correct.
I just wanted to ask you about the 3165, but
Yes.
you've answered that too.
If it's refused, well, yes, it is. Well,
No, it survives. It's an application for leave to adduce further evidence on appeal.
Yes.
If the appeal is not there, it falls
Yes,
away.
yes, that's correct, my lord. Actually, it brings that comment, which is correct, my lord, brings about the absurdity in what my learned friend, Mr. Breitenbach, was saying, that why did we not bring the 3165 application between the 21st and 26th of October last year? That's just ridiculous. Because how would we bring an application when there's no 316 application, which is the point your lordship makes? Because that application can only be brought in the context of a 316.
It couldn't be a 316 application.
Yeah, it would have been some
application.
other thing, which I
That'd be
don't
an
know.
application to adduce further evidence.
Yeah, but imagine that.
Yeah.
Imagine if there's a judgment that's reserved, and then it's coming in 4 or 5 days, and then we rush here, presumably on an urgent basis, to say that in case you find against us next week, we want to do I don't even know how to articulate it, but yes, your lordship is quite correct. The application for adducing evidence can only be done in the context of an application for leave to appeal. And until we had your judgment, there was no, the appeal sections of the Criminal Procedure Act had not kicked in, including 3165. Anyway, so my learned friend, Mr. Breitenbach, also says that that evidence is irrelevant. Well, I think the less said about that, the better. Because how can it be relevant that Mr. Downer, irrespective of which way the court finds or doesn't find, that he allegedly divulged NPA information to Mr. Soul, and that he allegedly, well, not allegedly, this time there was a confession, that in the context of these proceedings, he interacted with a newspaper person from News 24 regarding Mr. Zuma's confidential medical report, which is admitted under oath. But when you lay a charge in respect of that and now graduate this from a mere conjuncture, suddenly it becomes irrelevant. And that's well, my lord, I don't know if my learned friend might object, but I can tell you from the bar that we have received a letter from the NPA, from his client, last month, I think, which says that that matter is under investigation, as anyone would expect. So that's all. The only point we make is that there's a matter which is under investigation. We're not saying he was convicted or whatever, or even charged. We're saying there's a matter where he's a criminal suspect in a matter, and that is very relevant as to whether or not he can be a criminal suspect from a complainant who's sitting here today, and then tomorrow he can be the impartial prosecutor of that same complainant. The person who went to the police station and said, you are guilty of this and this, you should go to jail. And the following day, you just switch some light and suddenly he's a prosecutor with a title to prosecute. As sometimes they say, fact is stranger than fiction. So, it's not irrelevant. It goes to the heart of the title to prosecute. And I must say this again, the title to prosecute in the first instance of Mr. Zuma by Mr. Downer. Whether that might result in a replacement, remember that our discussion on the continuum, my lord, or an acquittal is not a matter that is now before this court. But our complaint is simply that a complainant in a police station must be prosecuted by the suspect that he says stole my car or did whatever. If that is our law, well, so be it. But I suspect a higher court might find it different. And so that evidence must be then taken as true, because I've already addressed this other submission about that we should have done it that we have not adequately explained why it was not brought either by the 22nd of September or by the 26th of October. The last point, my lord, is the issue of I'm sorry, there's one more point. The issue of section 317. I'll just leave it here. A special entry may be entered, yes, my learned friend is correct, in relation to the trial proceedings, but the section says, or proceedings in connection with such proceedings. And I won't belabor the point. We simply will argue that the irregularity complained of in this particular case was clearly done in connection with the proceedings, if it was not in the context of the entire trial. And that is important, particularly in terms of 317, because that is the one that I reminded the court that the court, quite frankly, has no option. If the issue is entered, then the issue must, rather the court must grant leave to appeal. In fact, my lord, that notion is summarized in the commentary to 319 in Erasmus 31-34A. That's the 2011 edition. Just underneath the 319 reservation of question of law, Dutoit says Section 319 makes provision for an appeal on the basis of a reserved question of law and thus creates the third way in which a person who has been found guilty and in certain circumstances even not guilty in a superior court as a court of first instance may submit his case to the SCA. So subject to everything we've discussed, when they say third way, they meant you can bring such an application in terms of Section 316 or rather such an appeal 317 or 319. So these are all three separate gateways by which the SCA may be reached. Then, my Lord, if I may just give your Lordship in the morning, I promise your Lordship to give references of where what I said lied at the heart of your Lordship's judgment, which was the notion that this whole matter should be referred to the end of the trial. I won't read them. It's your Lordship. I'll refer your Lordship to paragraph 77, 78, 94, 114.
Sorry, how many four?
94.
94.
114, and more importantly, paragraph 135F that my learned friend referred to. So those are the 5 places. There might be others where the court specifically and emphatically stated that the matter should be would be best dealt with at that stage. I had another reference, my Lord, regarding the interest of justice, but I think my learned friend, Mr. Breitenbach, in all fairness, accepts, well, he doesn't, but he should, accept that it cannot be in the interest of justice to subject somebody to a trial, particularly of this magnitude and complexity, if that's all just in vain, and it's all being done by a prosecutor who has no title to prosecute. It'd just be the mightiest waste of taxpayers' resources and the time and scarce judicial resources and the time of the parties. And Mr. Breitenbach, well, suppose because he has to, valiantly tries to say that, well, this matter has been delayed before. Well, so what? He wisely does not go as far as to accuse Mr. Zuma of causing delay, for no reason, for the sake of the delay, other than to exercise his rights. And once that is accepted, my Lord, because unless you say, this whole thing, there's nothing wrong with the wide interpretation, there's nothing wrong with what Mr. Downer did, there's nothing wrong with all these things that have been, those 14 grounds that have been laid, and all that this is about is just some stratagem. Well, that case is not made. If it was made, we would reject it with the contempt it deserves. But once that case is not made, then your Lordship, then the 4 grounds, I think there are 3, there are 4. There are 3, but there's a 4th one that was added in a certain case, in respect of which your Lordship would be entitled to reject a special entry, for example, namely absurdity, frivolity, the
lack of good faith.
Yes, lack of good faith, and the 4th one.
Obviously, merits poor.
My Lord?
If the merits in the appeal are poor.
Yes. My Lord, not that I don't believe your Lordship, but let me just.
No, that one's not expressly. That was submitted an argument.
Yes.
The 3 that are referred to are the first three.
The three are the ones
Well,
that come from the...
That's my recollection, but feel free to check it, please.
Yes, no, Your Lordship is correct. They were set out in a case called S versus Motsau. It says, unlike the reservation of a question of law, I'm sorry, this is 31-32E of Erasmus.
You'll have to get me a copy, Mr. Mp.
Oh, yes, my lord, we will.
Our
by the
resources
way,
don't extend that far.
we do have no, give me there. We do have, it's not as legible as one would have liked it, my lord, but as they say, one must not look a gift horse in the mouth. But we
You can make it available to my registrar.
will, my lord. We can, actually, yes, we'll
Thank you.
email a properly legible copy.
Thank you.
Yes. But, my lord, and we'll even include this part. Unlike the reservation of question of law in terms of 319, an application for the noting of a special entry may only be dismissed on one of 4 grounds referred to in section 317, which is the 3 Your Lordship spoke about, namely that the application was not made bona fide, or that it was frivolous or absurd, or would be an abuse of the process of the court. Okay, in S versus Cosa, 2010-2 SACR 207 SCA, the court held that there was another ground not expressly mentioned in section 317, but inherent in the section, namely where the irregularity appeared from the record itself. In such a case, the special entry procedure might be unnecessary because of the wide powers of appeal the Court of Appeal has in terms of section 316, which is the point we made earlier. So none of those have been alleged, of those defenses. It has not been said that this application is not made bona fide, that is frivolous or absurd, and certainly that is an abuse of the process of the court. So the court has no option but to grant.
Admittedly, you say it hasn't been criticized or on that basis, but it was only raised in the reply.
This point.
No, the 317.
Sorry, my lord, I can't get
The 317 issue was only raised in reply.
in the replying affidavit. Oh yes, of course. Well, it was no, not really. It was raised in chief because it was not raised as part of the replying affidavit. If your lordship goes to that page 79 that we just read now.
79.
Yes, 78 rather, which is where the whole thing starts. It's called a conditional counter application in terms of section 319 and or section 317 of the Criminal Procedure Act. So in other words, it was only included here as we could have done a whole new notice of motion.
It was in the replying affidavit, that's all I
It was
said.
in the, well, no, my lord, yes, it was in the replying affidavit, but it was not raised in reply. It was a separate application where this is a, so for the purposes of what I'm saying, from paragraph 22 to 32, that would be a new affidavit, founding affidavit in that conditional counter application, rather than a replying affidavit. And incidentally, there was no answering affidavit, so that application, for, if we want to be technical, was unopposed. Because there should have been an answering affidavit to that conditional counter application, to which we would then reply. That would be the reply, not this. This is a founding affidavit.
Yes.
So if your lordship just bear with me, I think I'm finished, but I just want to check my notes. Right, my lord, all I can do is to take us, before I sit down, just to take us down to the first quotation I gave this morning to your lordship, to now paraphrase it in the context of the discussion we have had, particularly the Zweni type of discussion. And that will be the refrain that your lordship should find that it is surely not in the interest of justice to submit an accused person to the strain, expense, and restrictions of a criminal trial if that can be avoided in appropriate circumstances by allowing an appeal to be pursued out of the ordinary sequence, and so obviating the trial or substantially shortening it. And that, with those words, those are our submissions, my lord, that the matter is appealable, but that for the reasons that Mr. Masuku advanced on the merits, even if the worst comes to the worst, the issues, those 14 issues, we promised this morning that we won't revisit them, but at least some of them, and particularly those that were not disputed, such as the Mr. Soul incident, the fact that Mr. Downer cried when the charges were withdrawn, and all sorts of issues like that that were not disputed. Putting aside all the disputed ones, because they will lead us to this whole issue about whether there should be a referral to trial. I don't want to enter that debate now. I'm simply saying purely on the 3 or 4 undisputed, admitted complaints, then your lordship, in our respectful submission on the merits, ought to have found that there is sufficient threat and violation of the Section 35(3) rights to warrant a stripping of the title to prosecute in this particular case. Again, we accept and respect your lordship's judgment, and our submission is simply that another court might be sufficiently alarmed at what is being suggested here. And my lord, let me just say this, maybe for the sake of completion. There is always this innuendo that President Zuma, and I accept that Mr. Breitenbach did not make it, but out there, that all these points that he's raising are points which are to avoid the trial. Well, nothing could be further from the truth. He is entitled to all the protections that are provided by our law, by our constitution, and by Section 106(1)(h) in particular, not to be tried by a prosecutor who harbors ill feeling towards him, or at least that he perceives to be. And my lord, those so-called experts and commentators who accuse all of us of this, fail to answer one simple question. If it is President Zuma's intention to do that, then why does the National Prosecuting Authority and the state not call his bluff? Why? Why do they have to, we have to go through all this so that Mr. Downer must prosecute? Are there no other prosecutors in this country? If there's anyone who's delaying this trial unnecessarily, it is them. Because they should have said, okay, we know he's doing his tricks. Let's call his bluff. We will remove Advocate Downer. We will concede his non-title to prosecute, even if we don't like it, and we'll bring Mr. Van Graan or whoever. who's going to do the prosecution. No, they must cling and hold on for dear life to this one prosecutor. It is their door that any delay. But Mr. Zuma must never be accused of delaying justice when he's only asserting. Otherwise, people must go to Parliament and scrap Section 106(1)(h) of the Criminal Procedure Act and Section 35(3) of the Constitution. Then that's fine. Then let's have a kangaroo court and let's take him back to the gallows, maybe.
That conclude your submissions, Mr. Mpofu?
Those are our submissions, my lord.
Thank you.
The order is built into our application itself.
Yes, but you've also now...
I did not, my lord, I didn't address the question of compelling circumstances, but I think that is also built in.
Now you've mentioned it, yeah.
That's a court, please.
Very well. The application for leave to appeal is adjourned to the 16th of February, when I again hope to be in a position to give judgment. You can take it that I will deliver a short judgment on that day. If I, during the course of preparation, run into difficulties, then I shall advise the parties
Thank you, my
if the matter is going to be adjourned on that day.
Thank you, my
But
lord.
hopefully, as the last time, I hope to be in a position to present at least a summarized judgment, and then with the full written judgment to be handed down at the same time.
Thank you, my lord. Could ourselves and Mr. Breitenbach and Mr. Masuku be excused?
Yeah, it'll just be to note it.
To note the judgment, to send
yeah,
our
it'll be-
juniors. As court, please.
Yes.
Thank you, my
Very well,
lord. You are
thank you.
invited to the court.
Court arise.